Woo! Good afternoon, my friends. I hope everybody's doing well. It's great to see you guys. Oh man, had another fun walk with Clubber members only chat. If you're not members and you guys want to just have a nice relaxing stroll in the park in the mornings with me and Clubber, then yeah, become a member and you can join that chat while we do that. So thanks to all of you who were there this morning. It's a bummer because like what happens is like after a while, that's when people start like packing in, and I do those walks for maybe like half an hour to like 45 minutes tops. And so like so like by the time there's a bunch of people packed in there, like I'm ready to go home. But yeah. But yeah, I like hanging out with you guys in the morning, man. It means a lot. And you know, if you're members, you could always catch the replay. That's where I do my shit talking. That's where I stick to petty stuff there. I leave the petty stuff there. Because so many people want to whine about it. So, well, you're watching it. So, guess what? If you're gonna watch it and you're gonna whine about it, well, you're gonna have to pay to whine about it. So yeah, Liz88 gifted a membership. She's amazing. Thank you so much, Liz88. Yeah, man. So I'm gonna yesterday I went over the SJC filing from Attorney Bradel and Kelsey Fitzsimmons' team to overturn the judge's decision as far as her bail requirements, and to let her out of jail. Like she's in jail. She's got a 5th surgery scheduled coming up from getting shot, and she's in jail. Why this isn't pissing everyone off is beyond me. But yeah, we're gonna read the rest of that, and we're also gonna go over the most recent Fraser Bohm hearing. Fraser Bohm is the new client of Alan Action Jackson, and I'm interested in that because I'm even more interested. I was interested in it at first just because it was in another high profile Alan Jackson case. But now it's gone beyond that, because now I'm questioning whether or not this kid is guilty. And I mean, I this is what you do. You know what I mean? Like I always presume innocence. As best as I can, I always presume innocence. You know, sometimes the information made available to you is so overwhelming to make you lean towards the guilt of the person who's suspected. And you know, if we're going to have any faith in our justice system whatsoever, you know what I mean, once in a while you're going to come across some cases where the person deserves to be prosecuted. Now, I have not made this decision in my own mind as far as Fraser Bohm goes, but I'm interested, and really, I'm really interested to see if Alan Jackson can get his client to, and maybe he doesn't need to. Maybe Alan Jackson feels the same way about Fraser Bohm as he did about Karen Reed, in the sense that he's like, well, I don't care that he swivels around in his chair, and I don't care that he looks like he has better places to be. He's not guilty here, so it doesn't matter. The problem with that, though, is is that you have 4 young girls who are dead, and you have 4 young girls who are dead. Well, and I don't want to say young girls like as if they're children. They are sorority sisters or college girls, and they had their whole lives ahead of them. And the question is whether or not this guy was just driving recklessly, and through his recklessness cost these young ladies their lives. So yeah, exactly. I mean, I'm not saying that's the case either. I mean, that's your opinion, and I respect that opinion. And I'm not saying that I disagree with you. I'm just not saying that I agree with you yet either. But murder, yeah, murder is a bit of a reach. And it does seem politically motivated. It seems like, I mean, that's the only logical guess. That's the only logical, uneducated guess is, okay, this is politically motivated. But before we get into that, we're going to get into the Kelsey Fitzsimmons SJC filing here that we started yesterday. We didn't finish. Yeah, I mean, I obviously it wasn't murder, and like they would have to prove motive, they'd have to prove intent. It's just kind of ridiculous that they're trying to charge him with murder, and that's probably what we should really be focusing on here.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Yeah, Tracy Cooley, thank you so much. I appreciate it. But anxiety meds, I mean, that's a reach. That sounds like somebody who just wants Alan Jackson to win because we like Alan Jackson. And I like Alan Jackson. And, I like to see Alan Jackson win, but I also like to see justice served when it's necessary. I just have not reached the conclusion yet that, but where I'm leaning right now is, okay, the kid was probably driving recklessly, but murder, I don't know. Now, mind you, when I first started following the Karen Reed case, my mind was she most likely got drunk and got in some argument with her boyfriend, backed out angrily, and then ran into him and didn't realize it. Still giving her the benefit of the doubt, but at the same time, like not jumping to some conclusion that she's being framed. Turns out she was framed. So who knows? Who knows how these things work out? That's why I'm going into this with a very, very open mind. I'm not automatically rooting for AJ. I like AJ and I like to see him win, but I also, like I said, I want to see justice served. But I'm really rooting for him to get these to beat this murder charge, because the bottom line here is, they could probably come up with a plea deal where there's a lesser charge, but I don't know. I mean, I just don't see anyone. I don't see California being as tenacious and stubborn about these kind of things as Massachusetts proved to be in the Karen Reed and Aiden Carney cases. So, oh my God, there's 2 of them, so we got to do it again.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Thank you so much, Dina. December 5th, I want to see all you mofos at TB's hearing, at Turtle Boy's hearing. Show your support for Turtle Boy. Yes, agreed. All animals matter. Thank you so much for the fur babies. Oh man, that's awesome. Thank you. Yeah, they are I guess the cold, man. I don't know what it is, man, but they become very, very, very affectionate. They're in a very festive mood. And they want to cuddle all the time, which is great. I tell you, I slept like a baby last night. Because just the two of them were all cuddled up with me, and it was just heaven. And I slept wonderfully. They slept all through the night. I slept all through the night. It was just great. I tell you, I've talked about this so many times, man. I'm telling you, I think I'm good on the desire for a lady friend, or at least a live-in one. That's for damn sure. I think I've bypassed that shit, and just reached an age where I was just like, I don't give a fuck anymore. Because I'll tell you, it's a peaceful existence. Me, Clubber, and Drago. It's a peaceful, very chill existence, and I love it. I absolutely love it. I don't see any reason to fuck that up. Bring somebody else into the dynamic. There's no reason for that. There's no reason for that. Right. I just never thought that I would. Me, I've always liked having a woman in my bed. I've always enjoyed that. But now I'm just like, I don't care. I just don't care. It's great. So yeah, just the whole freedom. Like the stuff that, like, it's funny because there's stuff that people would like criticize me about, like the lifestyle I live, and the material possessions that I choose to own and choose not to own, and just kind of living more or less an unorthodox lifestyle for somebody my age. But I got to tell you, the cool thing about being my age is not giving a fuck about how people feel about it. Just don't care. It's fucking great. Liz 88, thank you so much. I'd rather share my bed with a dog, for real. I've said it many times, man. I might meet a nice special fucking lady friend. That might happen, but if she doesn't like sharing a bed with a dog, I will be a gentleman and I will make a nice, chill, very comfortable spot, as comfortable as I can on the floor for my new special fucking lady friend. I'm perfectly cool with that. But Clubber, as long as Clubber wants his spot in the bed, it's his bed. It's absolutely his bed. Hold on a second here. Dude, and I'm serious, man. I totally, like, yeah, my dog snores and I love it. You know what I mean? Like, you're like a snoring husband. Dude, Clubber snores loud as fuck, and it actually relaxes me. It actually, like, it soothes me hearing Clubber just like it's the most adorable thing, and he's always done it since he was a baby. He's always done it. Closet lady. Closet lady. No, Clubber, he doesn't fart, which is pretty great. I can't stand snoring either. I can't stand it, dude. I dated a girl who snored, and I tried. I'll tell you, I tried. I couldn't do it. Like, I couldn't do it. It lasted maybe a week or so, and I was like, this is not gonna work. I can't. There's no way. Like, the only way is if I like drink myself to sleep every fucking night. No, I'm not doing that. No. So like, yeah, I love chilling with my dog, man. And I love that he snores, and I love that and I love that he um he dreams and he howls in his dream. Like, he never barks. He never barks or howls, but in his sleep he'll howl. And he'll go like as he's like and in between snores. It's fucking the cutest thing. He did it the first night he stayed with me, the very first night, and I just completely fell in love with him. I was like, this is just the most adorable goddamn shit ever. And that's it. Yeah. And he like, I pick his fucking he always lays, like, when I'm watching TV, he lays on the same spot. He lays, like, I'm under the blankets, he gets on top of the covers, but lays in between my legs. And ever since my knee got hurt, he has always laid his head on that knee. So he's in the exact same spot in between my legs, the same position, same spot every time. And then lays his head on my bad knee. And it always made me feel better. You'd think that it would hurt. You'd think that there would be pain where I'd be like, ah, fuck, Clever, don't do that. You know, but no, like, it made me feel better. It made my knee feel better. And I would go to sleep and I'd sleep. I didn't have almost any trouble sleeping throughout this entire knee injury. And so, yeah. And Clubber, after a while, like, when I'm ready to finally fall asleep, I'll pick his fucking 75-pound ass up and drag him up close to me, and then I will cuddle with him, and my hand will go like under his armpit and then under his chin. Like, that is the position we sleep in every night. And he falls asleep, I fall asleep, we sleep like that all night, and it is fantastic. Why would I fuck that up? Why would I fuck that up? It's just great. It's the most comfortable shit in the world. Let me find my place here. Because I don't even remember what page I was on. So I'm just going to skip to the trial order. The trial court's order must be reversed. And it says here, in supporting its decision, the court restored to attacking the attorneys on alleged procedural deficiencies and manipulation in its written rulings on the events of September 11th. And in denying the reconsideration and ignoring the medical evidence it claimed was initially missing. The court apparently forgot that at a prior hearing, the court suggested and the defense agreed that the facts in the prior filings would be incorporated by reference, so all facts could be before the court. Okay, let me read that again. The court apparently forgot that at a prior hearing, the court suggested and the defense agreed that the facts in the prior filings would be incorporated by reference, so all facts could be before the court. So basically, I don't know. Maybe I'm misunderstanding that, but it seems like it's just like already kind of a disclaimer. Everything that is available is already before the court. Everything is there. So I don't need to sit here and reference shit every single time. we've all agreed that everything has been referenced. At least that's kind of how I'm taking. I think that I'm probably kind of wrong and kind of right about that, but I have no way to explain it. Anyway, in its ruling, the court apparently ignored. Okay, in its ruling, the court apparently ignored this position, claiming a lack of medical evidence and a lack of specifics on simple urine testing that is ordered and or referenced in court likely every single day and undoubtedly utilized by this very court over her several years of experience. Great point. So you're going to tell me over all of these years of experience, there's never, ever been an alternative presented to this judge, an alternative to a breathalyzer test, to a what do you call it, scram test. There's never been an alternative presented to this judge in all of her years on the bench and all of her years as an attorney. Prior to that, she's never even heard of an alternative for testing for alcohol besides a breathalyzer. Whereas a urine test would be more accurate. A blood test would be more accurate. You could just draw blood. She wouldn't even have to go. You could just draw blood, take it. She wouldn't give a fuck. Now, unless whatever her health, if she's having her health conditions, if she's having issues with her health conditions right now where it comes to thinning blood or things like that, I mean, I'm just throwing shit out there that could affect why it would be bad for her, like which would dictate why it would be bad for her to have blood drawn from her every day or whenever randomly, then okay, I get that. But still, there's a urine test. There's different means to be able to test this young woman for alcohol, where it's already argued over and over and validly. It's already argued that alcohol is not even an issue, that her drinking excessively at her own bachelorette party being singled out as an incident that would dictate that she has a problem with alcohol, an ongoing alcohol drinking problem. That's absurd. It's absurd. That's ridiculous. Otherwise, literally anybody who gets drunk on one occasion should be treated as though they have a drinking problem. Based on that logic. Unreal. The record appendix contains everything filed for the trial court's consideration and was, as far as undersigned counsel understood and expected, incorporated into the judge's state of knowledge on the bail determination as a whole. The court's focus on the state of the record was unexpected and inconsistent with the history of the proceedings. During the September 11th hearing for motion for relief, the court incorrectly stated that it had no medical support, whereas defense counsel had submitted a medical notice to the court prior to petitioner's initial release on September 8th, 2025. Now, remember, I had that question. I'm going to read this footnote in a second. I had that question. Remember when we were listening to the hearing, the September 11th hearing, and I was hearing it for the first time. I had just read, Cherry had sent me a medical report that stated she is going to suffer from chronic pain from breathalyzer tests. I mean, this would cause her chronic pain. Explaining all of her injuries, explaining how she could be affected, how her injuries could be affected. This was all in this medical report. And I kept asking, like, well, why hasn't the defense presented this to the judge? Why isn't the defense going, hey, we have this? What are you talking about? But here they're saying, well, they're answering my question. Here they're saying the judge already had that. So we're confused as to why she is so adamant about her taking this breathalyzer test. That's why it seems inhumane. That's why it seems like a torture tactic. The footnote here says, this is expecting 2 exhibits generated after the court's denials. The risk assessment prepared by Jenna Tinney, Jenna Tinney, Elsie's SW, and the Hampton County Sheriff's Department incident report, both generated after the trial court decisions. Nonetheless, these can be considered as part of the court's de novo determination. The medical notice laid out various issues Ms. Fitzsimmons was suffering with, including difficulty breathing, broken ribs, and other items provided, which was impounded at defense's request. Further, Ms. Fitzsimmons being shot in the chest is laid out in the initial charging documents filed, and certainly no secret in the matter. The court was aware as early as the second hearing on September 8th that Ms. Fitzsimmons had difficulty breathing due to her healing punctured lung and broken ribs. Common sense. Listen, I'm not a judge and I'm not a doctor, but my common sense dictates to me that I'm going to have trouble blowing as hard as I can into a breathalyzer if I've been shot in the chest. No matter what. I mean, if I've been shot in the chest, if I've got a punctured lung, and I've got a broken rib, I'm going to have a hard time breathing, much less a extended exhale as hard as I can to get an accurate reading from that breathalyzer, because there's a standard procedure as to how these breathalyzers are conducted. These scram tests are conducted. I'm sure I couldn't recite this procedure to you, but I'm sure that one part of that procedure is the person needs to blow out as hard as they can, as heavy as they can. They need to exhale as heavily as they possibly can to get a proper reading. Now, I've never had to take a breathalyzer test before, so I don't know. So I've taken field sobriety tests and fucking killed them. But I've never had to take a breathalyzer test. So I honestly don't know. But I mean, dude, even in the movie Superbad, remember they were doing it for the fuck of it? And they were like, go, 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 go. And the dude was like, you know, I imagine that the police want as much effort from the suspect of the DUI. I would imagine that the probation officer wants as heavy of an exhale as they could possibly get to get the most accurate reading. It's a good 10 seconds. Okay, so 10 seconds of an exhale. I don't think I could exhale for 10 seconds right now. There's no fucking way that somebody with a punctured lung and a broken rib is going to be able to do that unless they are fucking what's his face from Cinderella Man. That dude fighting with broken hands and shit. Like there's no, like I can't imagine being able to do that. So it's not a stretch to call this judge's decision inhumane and to call it torture. It's not a stretch to do that. In response to the court's revocation claiming a deficiency in the medical documentation, defense counsel further provided a court with a letter. Oh, I already read that. Sorry. The severity and duration of pain following such a fracture vary. And hold on, let me read this is more. Hold on. In response to the court's revocation claiming a deficiency in the medical documentation, defense counsel further provided the court with a letter from Ms. Fitzsimmons' trauma surgeon removing any issue whatsoever where he corroborated petitioner's medical notice and affidavit, her mother, and the ACPO, and opined, in my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement, such as deep breathing. The court ignored what it demanded in its denial of the reconsideration motion. The court also ignored the second to last sentence of Section 58A, which provides the judicial officer may at any time amend the order to impose additional or different conditions of release, meaning she had the power to do it. She had the power. 58A clearly dictates, it clearly states that this judge had absolutely the power to go, hey, okay, wait a second. I mean, my common sense is spidey tingling here, telling me that if she has a broken rib and a punctured lung, it's probably hard for her to breathe. So we're going to figure something else out here. I mean, that's what anybody with a heart would do. That's what anybody who lives that life of a judge who took an oath and believes in the oath that they took to serve justice, to treat every human being as though they have equal rights, because they do. And here she is not showing that she's living that life, showing that she's not living that life. Wow. Ladies and gentlemen, this is your captain speaking. Fasten your seatbelts. We'll be taking off shortly. Fredo will be Fredo 12, flight Fredo 1267I will be taking off shortly and departing the airport. Make sure to buckle up, and we'll get you on that landing strip as soon as we possibly can. All right, and have a safe flight. Thank you. Fuck off, Fredo. Further, the court erred in citing 58A as the applicable circumstance and found non-compliance. However, this was not a reopening of a 58A. This was a revocation under 58B, which clearly, as set forth herein, did not conform to the requirements of such action. Further, the court misstated the record, alleging that defense counsel did not provide alternatives to scram breathing. Urine testing is a common tool used by the trial court every day, and not a complicated or obscure request by the petitioner. Now, that's a great point. Because honestly, this is the first time I've ever heard of a breathalyzer test being the means in which to test somebody for alcohol when they're on bail release, when they're released on bail. This is the this is the first time ever hearing of this. I've always heard of someone who was on bail who had to stay sober of having to take piss tests, supervised piss test, where somebody stands there behind you and you pee in a cup in front of a fucking urinal. That's what always fucking happened. It was always urine testing. That or hair follicle testing. The rare occasion hair follicle testing, depending on the substances that you were told to be kept off of. So it's actually weird to me that a breathalyzer test is being employed here instead of a urine test in the first place. So, yeah, Connor McManus, you're next, bro. Banning your ass, bro. I mean, I didn't even ban this guy. I just fucking told him that nobody gives a fuck if he leaves. Nobody cares. Council did, in fact, reference testing alternatives at several times during the September 11th Scram hearing. Okay. Unfortunately, the court's demeanor severely curtailed any elaboration from probation or counsel, culminating in the court preventing any further discussion by walking off the bench mid-argument of undersigned, blah, 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 blah. The defense requested alternative testing, which was readily available and reserved specifics for the time being to avoid further enraging the court. And the court leaving mid-argument prevented the remainder of this information coming out. So basically, because I remember thinking, like, why didn't Bradel argue that there's just for the sake of being thorough and patronizing this fucking cunt of a judge and being like, okay, fine, I'll indulge, Your Honor. Urine testing, blood testing, one of the many other much more commonly used methods of testing when someone is on bail than a breathalyzer, especially one with a broken rib and a punctured lung. So I wondered about that. But it turns out that when he's trying to do this, she's mid getting up out of her seat and then walking off the bench in a rage. Angry, mad. She fucking rage quit the hearing. The judge rage quit the hearing, bro. The judge beat him to her own fucking hearing, bro. What is that? It's bizarre. The error of law in single justice session. Here, the single justice clearly misapplied the highly differential abuse of discretion standard rather than rather than the foregoing de novo principles. They found that following close review of the defendant's petition and appended materials, the Commonwealth's opposition and appended materials, including a transcript of the hearing held on September 11th, 2025, and the judge's orders, this court concludes that the judge did not commit an error of law or otherwise abuse her discretion. Of course, she's going to say that about herself. Although largely academic in light of the overarching impropriety of jailing, Ms. Fitzsimmons, regardless of which law applies, the single justice also wrongly applied the basis for the surrender, choosing blah, 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 58 over 58B, 58A over 58B. Section 58A, setting out the conditions where a dangerousness hearing can be reopened, was not followed by the court. That provision requires due process, notice, and opportunity to be heard as spelled out in the section. Ms. Fitzsimmons was there under 58A seeking a hearing to amend her release conditions. She was not in violation of any provision and was neither a Commonwealth nor a probation department target of a revocation or a reopening of the dangerousness hearing. The judge was the only person aware of a reopening of such a hearing where reincarceration was planned. As such, none of the procedural safeguards were honored as set forth in 58A, i.e., notice that such a shocking result was even being considered a right with the knowledge to call witnesses, have informed counsel to the right to right to testify, cross-examine, and present witnesses, and to benefit from a correct interpretation of the relaxed rules of evidence. In that respect, the court further erred when it misstated the standard for using hearsay in a probation hearing. The court improperly stated in the hearing that the email from probation is not evidence. It's an email, it's hearsay. And this is an email from a probation officer. The court gives that zero weight. Now, I'm going to elaborate on that a little bit here. That shit's bizarre. The fact that she dismissed an email and saying that that wasn't evidence. Of course it's evidence. Of course it's evidence. It's in writing. It's from a probation officer, someone assigned by the court. Of course it's evidence. How could that not be evidence? And what fucking, on what planet is that not evidence? Bro, Save the Turtle just doesn't know where they're at. That's all. You know what's funny, though, is I didn't even get a super chat yet.
Oh, here we go.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat.
How dare you?
See, no super chat required for me to play the song. That was just for you. That was just for you. Specially dedicated. Go fuck yourself. Yeah, I found it weird that she tried to say that an email from the probation officer is hearsay. That's insane. That is insane. Yeah, so the court's determination on the email from Assistant Chief Probation Officer Jeffrey January. Oh, wait. Miss V, USMC gifted 5 memberships. Thank you, Natasha. I appreciate you. We'll use the last one as the super chat for that one. So it says here the court's determination on the email from Assistant Chief Probation Officer Jeffrey January as hearsay and not evidence is an error of law, as the rules concerning admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness. Of course, that's evidence. In its September 16th decision, the court asserted that hearsay must be reliable and there must be good cause for the decision not to present live testimony. Dude, how is the guy who actually gave live testimony, how is an email from him not admissible? How is that hearsay? That is insane. The guy actually testified in that September 11th hearing. That guy actually testified. What are you talking about? The probation officer testified. We're talking about a probation officer's email. And she's saying that that's hearsay, and the guy fucking testified under oath in court. That makes no sense. Yo, this lady is fucking wacky, bro. In doing so, the court failed to acknowledge the abandonment of the good cause requirement as stated in Commonwealth versus Henderson, which states ordinarily the revocation judge should excuse the witness originating the hearsay information only for good cause. However, if the hearsay information satisfies the standard of substantial reliability or trustworthiness, like from a fucking probation officer, I don't know, maybe, the need to show good cause disappears. Accordingly, the court was applying a legally faulty standard to the evidence presented by the defense and should have fully credited his contemporaneous documentation of Miss Fitzsimmons' difficulties. Miss Fitzsimmons was deprived of all these safeguards, hardly the embodiment of the promise in Brangen Supra. Go Bradle. The pretrial incarceration occurs only in carefully circumscribed circumstances and subject to quite demanding procedures. The court also did not satisfactorily consider or use the least restrictive alternatives and did not meet the clear and convincing evidence standard. Where 58A is in opposite, it follows that Miss Fitzsimmons was wrongly surrendered in violation of GL Chapter 276, Section 58B. The only other provision available, Section 58B, limits the circumstances under which a trial court judge may surrender or revoke the 58A release of a detainee as follows. And I'm going to go ahead and read that because I feel like that's going to be very helpful. Section 58B, a person who has been released after a hearing pursuant to sections 42A, blah, 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 and who has violated a condition of his release shall be subject to a revocation of release and an order of detention. Now, that tells you right there how old this goddamn fucking law is, how far back these dates go, because, I mean, women didn't go on trial. You know what I'm saying? Women didn't commit crimes back in the day. She couldn't have done that. No. There's got to be a man responsible for this. We're going to find out who. There's got to be a man behind this. The judicial officer shall enter an order of revocation and detention if after a hearing the judicial officer finds that there is probable cause to believe, that there's probable cause to believe that the person has committed a federal or state crime while on release, or clear and convincing evidence that the person has violated any other condition of release, and 2, the judicial officer finds that there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of another person or the community, or the person is unlikely to abide by any of the condition or combination of conditions of release. Well, since it's only going based on some asshole's word and all evidence, and her physical condition dictates that she couldn't if she wanted to, then wrong. So she had no justifiable reason to revoke Kelsey Fitzsimmons' bail. There was absolutely no justifiable reason for this. By the plain words of the statute, orders of revocation and detention are only permissible if 1, there is a clear and convincing evidence of a violation of release, and 2, there are no conditions of release that will assure the safety of any other person or the community, or the person is unlikely to comply with a condition of release. Here's the court's sal sponte imprisonment of Miss Fitzsimmons runs afoul of the statute. Miss Fitzsimmons did not violate a condition of release. She was there in good faith to avoid difficulty going forward. Okay? And besides that, she took the breathalyzer test, she took the scram test, and passed it anyway, despite the fact that it put her in excruciating chronic pain. Despite this, she still passed. She merely wanted to amend these conditions. She merely wanted to find, is there any other way? Can we just do something else where I don't have to try to breathe so hard? I have a punctured lung and a broken rib. This really hurts. Is there anything else that we can do? How dare you ask me that? You're going back to jail. What? What? I mean, I don't know how much I agree with that, but I'll tell you that I feel like that's a justifiable position to have for people to feel that way, considering what she's going through in jail right now. She has a trans woman right now harassing her. Some woman with male DNA, male muscle tone, and a dick is threatening her in jail. She's a cop. And don't tell me that this trans person is not dangerous, because the trans person's in fucking jail. They wouldn't be in jail unless they were fucking considered to be dangerous, would they? The Commonwealth, to its credit, recognized the situation as such and only wanted her to continue to be tested. When asked for its position of evidence, the prosecutor said no evidence to submit other than the arguments that I talked about, how the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done. Translation, the prosecution is saying, translation, we don't give a fuck how she gets tested. We just want her to get tested. We don't give a fuck. Doesn't matter to us how she gets tested. Now, it would have been nice if they would have been like, Your Honor, considering her physical ailments, the Commonwealth does not have a problem with, an alternative means of testing. The Commonwealth does not object. As a matter of fact, the Commonwealth would even encourage the court to provide another means of testing to amend these conditions to some degree within reason. Like, that's what an ethical prosecutor would have done, in my opinion. Like, what's the problem here? Dina, thank you so much. The judge is a cunt. I know. I know.
Twat.
Yes, that, and wait.
Oi, cunt.
Yes.
You're a little cunt.
Yes, that too. Nor did probation seek any hearing on revocation or allegation of noncompliance or notice of surrender. To the contrary, Assistant Chief Probation Officer January fully supported an alternative testing means, but was completely shut down by the judge, who became increasingly angry that he was conforming and corroborating the defense's motion with his own personal knowledge. He said, as recorded, My first job when I get an incomplete test is to gather more information, right? Which is what we do. So in response to the incomplete test, we call Elmo. No, not Elmo. We gather the information, which is she answered the alert to take the test as scheduled. She unfortunately was unable to complete the test because she was unable to blow as long as or as hard as needed to complete the test. So ultimately at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test. It couldn't be more clear. This is from the probation officer whose report is required by the judge. This is the person who the judge is going to listen to whether or not she is meeting the requirements of her probation. And this person is going into detail saying she had difficulty. She had difficulty. I think they even testified at one point that they felt bad. She had difficulty. But eventually she passes the test. Eventually she completes it. I mean, that's not crazy. In conjunction to the hour and 20 minutes, we also know, and I observed it firsthand, that whatever the injuries are, and I don't know, and actually it doesn't really matter to me. When I was doing the installation process and observed what was genuine pain, this is coming from the probation officer. I'm going to read that one more time. In conjunction to the hour and 20 minutes, we also know, and I observed it firsthand, that whatever the injuries are, and I don't know, and actually it doesn't really matter to me, when I was doing the installation process and observed what was genuine pain. Court, any objection to any of the terms used by the probation officer? No? Okay. What? That's what the judge says. Any objection to any of the terms used by the probation officer? No? Okay. We have all that information. We don't deem that non-compliant. She is attempting to take the test, and she ultimately passes the test at 4:20. So with all that information, that's not non-compliant. That's compliance with her obstacles. That's compliant with scram testing. This is coming from the probation officer. If she had missed the test, she would generate additional responses from Elmo, and that would determine whether or not that was actually non-compliance. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I am aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone and then the court interrupts. The court interrupts here. And she says, well, that's your position. That's non-compliant. It's really up to the court to determine whether someone is compliant or not with conditions of release. She gets defensive. She says, this isn't your show. This is my show. That's what she does here. This judge whips out her dick and starts pissing. That's what she does right here. Lifts up her robe, pisses on the bench. Because he's like, I know what my job is. My job is to determine whether or not somebody complied or they didn't comply, and then I report back to the fucking judge. That's my job. That is his job. Otherwise, what the fuck's he doing there? So, what's he doing? This is his job. And now the judge is going, no, that's not your job. I say whether someone's in compliance or not. That's your opinion that she was in compliance. I say whether or not she was in compliance. And so I'm going to take away her bail and I'm going to throw her in jail right now. Fuck you and fuck her. That's what the judge just did here. It would never be brought to a court by way of pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation notice from our end because there are many reasons for a test to be incomplete. The goal is to test to ensure that the person is sober, and we don't deem that non-compliance. We never have, and we never would in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. The schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered for someone to be alcohol free. Now the judge interjects. What do you mean we discussed? So she knows when she's going to be tested? So right here, again, she's being defensive. The schedule for her to be tested is something that we discussed. It wasn't ordered by the court. What do you mean it was discussed? So she knows when she's going to be tested. It's like she's looking for anything here. Right now, she's looking at this probation officer like it's her and Kelsey, the probation officer and Kelsey against her, against the judge. The judge is going, why is everyone attacking me? That's what the judge is doing right now. Having a fucking tantrum and basically acting as though the probation officer just turned on her and is siding with Kelsey, and they're all in on this to get the judge. It's something that we discussed. What do you mean you discussed it? So you're saying that she knows when she's going to be tested. You give her a heads up. This judge is insane. And then it goes back to this guy saying, I discussed with Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency. And then the judge interjects here and says, it was random screens. Excuse me, Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me? We created a schedule as we always do. Not in this particular case, we always do. Court, it was random screens that were ordered. When we get an order and someone is placed on pretrial conditions, that include remaining when we get an order and someone is placed on pretrial conditions that include remaining alcohol free with scram testing, we always default to creating a testing schedule up to 4 times a day. Up to 4 times a day. Okay? So what's the difference if she knows about it or not? She doesn't have time to drink. She doesn't have time to be drunk. And she'll still fail a breathalyzer if she's sober the next day and drunk from the night before. If she got drunk the night before, went to sleep, and then they give her a test in the morning, she'll fail that breathalyzer test. She's not going to pass that shit. Any alcohol that's on her, any alcohol, she can't have any alcohol in her system. Not above the legal limit. That's not the condition. The condition is she can't drink, period. So the slightest trace of alcohol is enough of a violation to get her thrown back in jail. The slightest trace. So why in the shit is this judge getting all bunched up about this? Makes no sense. He goes on to say the only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. I want the test to be done randomly, with selected emphasis in bold. And then it goes on to say the court was incorrect and random testing was not ordered, according to Tim Bradle here. There is no such order on the probation contract, and undersigned recalls no such order. Regardless, whether random or scheduled, no loophole would have been created either way for undetected alcohol consumption. The court should have allowed an alternative testing method, of course. Even still, if she got piss tested, dude, it takes 48 hours. It takes 24 hours for it to be out of your piss. As I understand alcohol, it takes 24 hours. 48 hours or 72 hours from your blood. I think. I could be wrong. I think. But they're going to test her every day. They're going to test her every day. There's no loophole. The court violated the Americans with Disabilities Act. Ooh, okay. Now we're getting juicy, Tim. In finding that after a thorough review of all the arguments and submissions by the Commonwealth and Fitzsimmons, the conclusion remains unchanged, regardless of Fitzsimmons' claim physical limitations. The court violated Title II of the Americans with Disabilities Act, prohibiting discrimination against people with disabilities in pretrial services without reasonable modifications. I mean, yeah. At the time the condition was imposed, Ms. Fitzsimmons had recently sustained life-threatening injuries, including gunshot wound to the right chest, hemothorax with retained bullet fragments in the right upper back, moderate light hemothorax requiring chest tube placement, right middle and lower lobe pulmonary contusions with active bleeding, grade 4 hepatic trauma with active bleeding from the right hepatic lobe, comminuted right posterior 12th rib fracture, and a right anterior 11th rib fracture at the man, I'm determined I can do this. Costochondral junction. The 11th rib fracture at the costochondral junction. Ha! Fuck you. The U.S. Department of Justice Civil Rights Division has directly addressed the ADA's applicability to the situation in its information and technical assistance on the ADA guidance letter as follows. Title II of the Americans with Disabilities Act, ADA, protects people with disabilities from discrimination in state and local government services, programs, and activities, including law enforcement agencies, justice system entities, and juvenile and adult corrective agencies. Thank you, Warwick. Becky, alcohol will kill her if she drinks with liver injury. Yeah, probably, yeah. If she's got a liver injury, why the fuck would she drink? It's crazy. The ADA requires, and thank you, Warwick, the ADA requires criminal justice entities, including attorneys, courts, jails, juvenile justice entities, police, prisons, prosecutors, and public defense attorneys to avoid discriminating against people with disabilities. Entities must ensure that people with disabilities are treated equally in the criminal justice system and that they have equal opportunity to benefit from safe, inclusive communities. Non-discrimination requirements such as the obligation to provide reasonable modifications to policies, practices, and procedures, and the obligation to take appropriate steps to communicate effectively with people with disabilities. 18 also support the goals of ensuring public safety, promoting public welfare, and avoiding unnecessary criminal justice involvement for people with disabilities. As a result of her gunshot wound, Ms. Fitzsimmons has severely diminished lung capacity and suffers acute pain when attempting to inhale or exhale deeply. Her treating physician has medically opined that a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement such as deep breathing. Thus, an individual suffering from the conditions in which Ms. Fitzsimmons has would make an individual medically incapable of blowing with sufficient force or duration to activate or register a reading on a scram breath device. Despite these limitations, a scram device was installed on September 8th, 2025. On September 25th, 2025, Ms. Fitzsimmons, through counsel, filed a motion for immediate relief from scram, which was met with Ms. Fitzsimmons' immediate incarceration by the court. On September 11th, 2025, immediately following the revocation, she filed her motion for reconsideration, which provided the email from probation and requested reasonable accommodations, including an alternative alcohol monitoring method, random urine screens, aka. Finally, on September 15th, 2025, Ms. Fitzsimmons, through counsel, filed a supplemental filing, but the request for reconsideration was denied without a hearing. In doing so, the court explicitly referenced but ignored her physical limitations in the reconsideration denial opinion. The court revoked Ms. Fitzsimmons' bail and ordered her detained solely on the basis of her noncompliance with a physically impossible condition. Under Title II of the ADA, no qualified individual with a disability shall by reason of such disability be excluded from participation in or be denied the benefits of the services, programs, or activities of such public entity. Now I'm going to read this footnote here. Upon witnessing Ms. Fitzsimmons' inability to comply with the services demands due to her medical condition, Assistant Chief Probation Officer Jeffrey January attempted to bring the matter right back to the attention of Judge McCarthy Nyman, the presiding judge who had imposed the condition. However, Judge McCarthy Nyman had already left the courthouse for the day, and no immediate judicial relief was available. Wow. Radel goes on to say that the judiciary, including courts and probation departments, constitutes a public entity within the meaning of the statute and must comply with its mandates. There are numerous alternative alcohol monitoring options available, including transdermal scram bracelets, non-breath-based, random urinalysis testing, and in-person probation check-ins. Each of these medically appropriate, none of these are even drawing blood, dude. They're saying that you can even wear a bracelet that tests your skin for alcohol. It tests your skin for alcohol, completely painless. It just sits there on your fucking wrist. I'm imagining. It just sits there on your wrist and then detects through your skin whether or not you've consumed alcohol. What is the fucking problem? And it's made by the same exact technological company that makes the breathalyzer test that she's hooked up to. What is the problem here? This is fucking crazy. Each of these is medically appropriate for the petitioner and allows monitoring of substance use without violating the ADA or imposing impossible requirements. If this court deems conditions necessary for release, it is not too much to ask for the court to accommodate Ms. Fitzsimmons conclusively It is not too much to ask for the court to accommodate. Ms. Fitzsimmons conclusively demonstrated disability with an alternative testing method and not violate federal disability law to enforce a dubious procedural position. This footnote here says transdermal scram bracelets, non-breath based, although not currently available in Massachusetts, is like a breathalyzer for the ankle. The Scram, okay, so it goes on your ankle, not your wrist. Scram continuous alcohol monitoring bracelet provides 24/7 transdermal alcohol testing for hardcore drunk drivers, high-risk alcohol and domestic violence caseloads, by automatically sampling the wearer's perspiration every 30 minutes. The Scram Cam bracelet eliminates testing gaps and encourages accountability. Scram Cam not only supports sobriety, but also results in higher compliance rates with court orders and increases community safety. So basically, that was Bradle's little infomercial for the Scram bracelet to be used in Massachusetts. For some reason, it's not available. And so Bradle is using that little footnote space to promote it and say, this is why. And that's really slick. And I like that. I like that a lot. That's why I love Tim. It's so funny. He's like, transdermal Scram bracelets, non-breath based, although not currently available in Massachusetts. It's like a breathalyzer for the ankle. The Scram continuous alcohol monitoring Scram Cam bracelet provides 24/7 transdermal alcohol testing for hardcore drunk drivers, high-risk alcohol, and domestic violence caseloads. Dina gifted 5 membership. Oh my God, 5 membership by Dina. Oh my God. Justice Surf offered to pay for the other Scram device. Oh my God, that gets a song.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare
I love Justice Serve TV, bro. They're amazing. Make sure to sub up to them if you're not already. Yeah, they offered to pay for the transdermal monitoring unit for Kelsey. Right. Bradle is here basically just kind of using the footnote here to try to promote its use in Massachusetts, why it should be used, why it's a great alternative. And here we are with a case where it would have really helped Kelsey out. It would have really benefited everyone in the interest of justice here for her to be able to have that option. So he used that footnote to do that, which I think is great. And in conclusion, the court should have granted release on personal recognizance with standard stay-away orders. The court clearly dispensed with the safeguards that bail be revoked only after finding a violation of terms and that there be no combination of conditions that would allow the defendant's release. The court did not further the bail statute purpose of establishing the right of the accused in most circumstances to be admitted to bail. Quoting Commonwealth versus Finley, 1996, if this court believes there should be conditions set, there are ample alternatives to Section 58A incarceration for Ms. Fitzsimmons, all of which were assiduously avoided by the trial court. Sorry, my vocabulary is only so limited. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court, 1, address the bail determination de novo consistent with the application case law, and 2, grant Ms. Fitzsimmons liberty with personal recognizance and stay away order from the alleged victim under Section 57, no finding of dangerousness required, or Section 87, bail terms imposed with agreement of the defendant of the bail statute, and vacate the balance of the trial court order, including the provision handicapping the probate and family court from handling the custody and violation decisions in the case. Okay, I want to read that again. Not that whole thing. grant Ms. Fitzsimmons liberty with personal recognizance and stay away, and including the provision handicapping the probate and family court from handling the custody and visitation decisions in the case. So they're asking the SJC here, which I love. Like, why can't family court decide whether, isn't that their job? Why can't family court decide whether or not this child can see her mother? Whether or not this mother can see her child? Why can't family court decide that? Why is this judge overstepping her power, overstepping with her authority? Why is she doing that? So I just, yeah, I thought that was crazy. I thought that was just a really fucking horrible jab there. Like, well, wait a second. When I brought this up the other day, I was like, well, this can't be right. Why can't the family court determine that? That's what family court does. And they determine whether or not someone's a danger. They do that too. So if you're sitting there arguing, well, you know, there's a dangerousness factor here. Okay, well, that family court determines that shit too. So now 3, grant other such non-incarcerative relief in the alternative if the court deems 58A conditions necessary, and 4, send the case back to the Essex Superior Court before a different judge for the reasons set forth above. Wherefore, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court justices under the appropriate orders as above. And there it is, Timothy Bradle and Martha Coakley. I've got to remember Martha Coakley's name. I feel like a dick. But yeah. Let me, I'm going to step away for just a second, folks, and I will be right back. All right, folks. Thanks for waiting. I appreciate it. Let me do this real quick. So really strong argument by Tim and Martha. Very, very strong argument there. And I really hope that the SJC will find that motion and find it well. So what we are going to do, we're going to move on to oh, wait a second. Just for fun, just for shits and giggles.
I thought that was odd but interesting last night, where they told us that they were putting spicy things in her food. According to Cheryl last night, she claimed Erica no longer wanted to live, and so they.
This dude has like fucking 18 people watching him, bro. God damn, dude. God Damn, John DePP. Ray from Dallas's channel is indisposed at the moment. He's taking a 7-day timeout. Listen, Turtle. Listen, Turtle. Okay, so the federal shutdown's finally over. That's good. But we're gonna watch. What we're gonna do now is we're gonna watch this hearing. We're gonna watch Alan Action Jackson in action. And we're gonna watch this the people versus Fraser Bohm. And Alan Jackson is going to argue his motion to dismiss, which I don't think he got, but special thanks to Court Chopped. I'm gonna go ahead and share Court Chopped their link and in the chat. So I want you guys to stop what you're doing right now. Stop what you're doing. Go give Court Chopped a like and a subscribe. I dropped the link in chat. I'm going to wait for you guys. All right. Thank you guys for indulging me. Let's watch Alan Jackson here. Let's see.
That's not the law.
Can we agree that the faster you're going, the more likely it is to cause that?
Depends on how fast you're going. These are the same charges that Brian Koberger is facing. That's the point. Brian Koberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point.
Charges filed in the Malibu crash that left 4 Pepperdine.
That is a bold argument there, AJ. I mean, it's a good one. It's a good one. My client is being charged with the same shit as Brian Koberger. That's fucking crazy. From a car accident. What are you talking about, Judge? What is happening?
University students dead. Fraser Michael Bohm pleaded not guilty to the charges, while his attorney claims he was a victim of road rage.
Off to the right, that's Fraser Bohm. Immediately after he allegedly lost control of his BMW, hit several cars, and struck 4 Pepperdine University students, killing them the night of October 17th.
Speeding at the speeds of 104 miles an hour on a 45-mile-an-hour zone on PCH when he lost control of his BMW. We're charging with 4 counts.
Now, AJ argues that they have the wheels came off of the ground, so there's no way to actually determine that he was going 104 miles per hour. There's no exact number to determine. So there's a lack of evidence there. There's a lack of evidence issue right there. So that's what AJ's claiming.
Of murder and 4 counts of gross vehicular manslaughter.
The deputy DA in court said,
"You can't navigate at 104 miles an hour. So when you are choosing to drive at that speed in what is essentially a residential area, it's not an accident, it's an inevitability."
The car veered him off the road.
That started at Duke's.
That's a hell of an argument, too. That's a hell of an argument. It's not an accident. It's an inevitability. If you are driving at 104 miles per hour through what is essentially a residential neighborhood and on a street, on a road that is just notorious for having fatal accidents, then yeah, it's not an accident when you're going 104 miles per hour. It's an inevitability. I'm not saying that that's true. I'm saying that that's a great argument. Sarah, be creative. Thank you so much. Love you all. We all love you too, Sarah. Be creative. Thank you so much.
Person chased him and tried to push him off the side of the road. And when he accelerated to get away from him, that's when the accident occurred.
And that, says Crowd, is when the other driver was yelling at him
and bullying him. And this person, according to a distant family member, has a history of exceptional.
See, man, you got to be careful with that shit, dude. That word bully, that's either going to make people empathize or they're going to get pissed off because it's an overused word. A lot of snowflakes out there like to use the word bully. A lot of snowflakes say, oh, I was being bullied. I was being bullied. The problem is that the dude sitting there, the defendant that's sitting there, looks like a bully. He does look like one. I'm not saying he is one. I'm saying he fucking looks like one. Like a cliche fucking high school movie bully. High school horror movie bully. He just does.
Erratic behavior in the car when he doesn't like somebody else's driving.
189, please remember to be present. Appearance, please.
Well, Your Honor, Alan Jackson, along with Jackie Sporani on behalf of Mr. Bohm, who was present in court out of custody. Thank you.
Meg Marcos, along with Pauline Kazarian. Thank you. There it is.
Hello, Your Honor.
Hello.
Mr. Glandrick, he's here. We'd ask the court to recall the bench warrant that was, or the body attachment that was held till today's day.
So, thank you.
Thank you.
Okay. The matter's here for hearing on the 995 motion that Mr. Jackson's sprung file that I read and considered, as well as the utility's opposition and the defense reply. I read all of those several times, as well as the preliminary hearing transcript, and I have reviewed the exhibits for the preliminary hearing.
Bro, like, dude, you got a beatnik for a fucking judge, bro. Like, look at this guy. Look at him. This guy listens to Jack Johnson, bro. You know what I'm saying? Like, this guy's got a fucking hemp man purse. Guaranteed. He's got a fucking man purse made of hemp. Like, he is not going to like this kid. He already hates this kid. He presses apple cider.
That were admitted into evidence as well. Who's going to handle the Mr. Jackson? The
995, yes.
Yeah. How is that? I've read your submission. If you would like to add to it, this is the opportunity. Thank you.
That judge does not look like a thug, bro. That judge looks like fucking Crawford. Stop it.
Your Honor, thank you, first of all, for allowing us to be heard on this. I will try not to repeat myself. Obviously, the court has read our submission, read all the exhibits, the preliminary hearing transcript, but I think that there are certain issues that do bear on the court's ultimate determination, and I'm going to highlight those issues as best I can and as succinctly as I can. And it starts with one truth, a legal truth here in California. Speed cannot be treated as malice. Speed cannot be treated as malice. That is the rule.
I mean, I agree. You know what I mean? Like, manslaughter, maybe, but murder, like, I mean, speed can be treated as malice if there's a motive. If you could provide motive, like he had intent, like I want to kill these 4 girls. You know what I'm saying? Like, you know what I mean? Like, okay, yeah, that's malice. Sure, speed can be considered malice in that regard, but without motive, I don't see how that's going to fly. So I agree with AJ here. This is an interesting case, man. Like, I'm fucking sucked into this shit.
in the state of California. It's not made up by the defense, it's not made up by me. It's not a tagline. It's the rule of law in California recited in a statement handed down to the lower courts by the Supreme Court Justice Kelly Evans. Your Honor, this case
now he's quoting case law. So fuck my argument. You know what I'm saying? Like, he's quoting case law. He's just like, dude, California law says speed cannot be considered malice. You can't use speed as malice. That's crazy. He's quoting case law. That beats the shit out of any argument right there. He's like, by California law, I'm reading it, Your Honor.
Always required one thing and one thing only from the prosecution, and that is proof of implied malice. Not proof of negligence, recklessness, not proof that this was a tragedy, which it clearly was. They must prove implied malice, and the law is crystal clear that implied malice has two separate and independent requirements: an objective requirement and a subjective requirement. The prosecution has never satisfied either of those, certainly not the preliminary hearing. And I want to be very clear, right now, at least for the first part of my comments, I want to separate those two into different legal pillars. The first thing I want to address is the objective requirement. What act did Fraser Bohm commit that objectively involved a high probability that it would result in death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway?
Look at this kid, bro. He looks like he's got better places to be. Like, this judge hates this kid. Guaranteed. They're from completely different, like, they're cut from a completely different cloth. You know what I'm saying? Like, the dude with the fucking hemp bag hates the fucking kid with the Beamer. And the kid with the Beamer is sitting there looking like he's got better places to be.
I could not be clearer about this. It was a tragic collision. But tragedy does not equal murder. And the law does not permit the district attorney to convert a fatal accident into second-degree murder simply by calling speed malice. Because we go back to that first postulate, speed cannot be malice.
Are we looking at the same guy? Like, someone said, are we looking at the same fucking guy? Are you kidding me right now? This dude right here rolling his eyes, swirling around in his chair. He looks panicked to you. He looks terrified. Yeah, AJ probably hates his fucking kid too. That's very funny. I mean, yeah, like, and yeah, he looks angry. Sure. He looks angry, you know, but the bottom line here is, like, if you're trying to argue that he has no malice, like, he's got malice written all over his face if you're looking for it. It may not actually be malice, but if you're looking for malice, it sure as fuck resembles it, doesn't it?
In California. Rather, there was no alcohol, no drugs, no texting, no racing, no distraction, no prior DUI by my client, no advisements, no Watson warnings, no statement of indifference after the fact, no criminal history, no driving history, no bad driving history, no serious consequences imposed by the government in a judicial proceeding. Nothing that has ever been cited in the cases where implied malice has been upheld in California. So what are the people left with? What are they left with? All of those no's, one after another, after another, after another, Judge, all of those no's make them rely on one thing and one thing only. And this is the basis of their entire theoretical postulate. Speed. That's it. Alleged speed at that. Disputed speed. Undefined speed. And now, after apparently abandoning that exact theory, which is what they argued at the preliminary hearing, they want this court to treat speed alone as implied malice. And that is not the law. That brings us to the fundamental problem in their briefing and in the magistrate's ruling. The prosecution has misstated or did misstate at the preliminary hearing the legal standard, and the magistrate clearly accepted that incorrect standard. They collapsed the two prongs of implied malice into one, the two prongs being the objective and the subjective into one prong, and they continue to do so even as recently as their reply. The reply brief that we received this morning states, quote, "The objective and subjective determination of the lethality of speed." That is a direct quote from the prosecution's reply brief from this morning. They still are conflating and combining the objective and the subjective factors, and the law says you cannot do that. And they're doing it on the back of, quote, "the lethality of speed." They go on to say in the reply brief in a two-page reply, in addition to speed, he also lost control of the car. Well, Judge, by definition, every crash involving speed is also going to include the loss of control of the vehicle. Otherwise, no crash. And then they throw in as almost a Hail Mary. And by the way, the defendant, quote, "was aware that he did not have full control of his vehicle prior to doing so," end quote. No citation, no quotation to the record, no citation to the transcript, nothing. Just a blatant, bald-faced statement with no foundation in fact. Where is the evidence? What evidence did they produce and present to the magistrate that my client, quote, "was aware that he did not have full control of his vehicle prior to doing so, prior to speeding"?
It's a great point.
There is none.
The burden of proof is on the state. The burden of proof is on the state of California in this case. And if they are failing to provide the proof, then there's grounds to dismiss here. I mean, of course. I mean, but I don't think AJ expected this case to get dismissed when he filed this motion to dismiss. I don't think he expected it. But he's putting up as good of an argument as you could put up here. Like, if they're failing to provide the evidence, then there is no evidence. I mean, where's the malice? This is a murder charge. Four sorority girls were killed in a tragic accident here. Like, how is this murder? I understand maybe manslaughter, maybe, but I seriously doubt this kid was like, I'm just going to fucking put the pedal to the metal and just run into these cars. What? Makes no sense.
They collapsed the two prongs of implied malice, as I just said, into one, and they applied pre-Reyes, and the court now is very familiar with Reyes, the 2023 version of CalCrim 520, both of which, pre-Reyes and the prior CalCrim, do not control. They are no longer the law. And the prosecution got the law, and they argued the law wrong, and the magistrate, unfortunately, got that law wrong. The California Supreme Court's current rule on the objective prong of implied malice is set forth in the new 520 CalCrim, and the case is post-Reyes. Before we go any further to the facts, the record, the evidentiary defects that were at the preliminary hearing, we need to start with what the Supreme Court has already started for us, and that is the Reyes case. Because if this court applies the law as it exists today, which this court must do, not as it existed before 2023, then the murder counts cannot stand. They are legally infirm. Period. Full stop. The Supreme Court in Reyes made it unmistakably clear that to prove implied malice, the act itself must involve a high degree of probability, not possibility, probability, that it will result in death. That's not a risk, Your Honor. That's not a possibility. That's not dangerous in some generalized way. We can have possibilities
first of all,
and danger.
He said it. Period. Full stop. Fucking love that shit. Second of all, this is where it gets tricky. His argument here is not a high probability, not a high possibility, but a high probability. There could be considered a high probability that this accident would occur, considering the history that this road has, considering the death toll that it has. I mean, it could be argued that there was a high probability. I'm not saying that there was. I'm saying that it could be argued.
That still do not reach the level of implied malice. It must be a high probability of death, not just a probability. And that means significantly more likely than not. I tried, as I was preparing my arguments today, to put this in terms that ring true to we lawyers and the community members at large as well. A high probability of death means it is significantly more likely than not just 51%, not just more likely than not just the famous scale to a feather, significantly more likely than not that you're going to kill. Someone when you commit that act. That you're going to kill someone when you commit the act. They rely on speeding. That's it. That's their entire theory. I've provided the court with 2 copies of the Calcrum. I just wanted to make sure that we're absolutely crystal clear about the language difference between those, the old and the new. One copy is the Calcrum that people actually relied on. It was superseded and is no longer law. And one copy is the instruction post res, and that is the current law. In the old version, the
Andrea's like, he's a little rich shit. Fuck him. That's just very funny to me.
objective standard, what I might have been arguing 10 years ago, before Reyes, highlights that, quote, the implied malice requires an intentional act. The natural and probable consequences of the act were dangerous to human life. So be it. That's what the law used to be. But the correct law regarding the objective standard now reads as follows. The defendant has implied malice if he intentionally committed an act. The natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that it would, not may, it would result in death. The clearest language used by any court since Watson, defining a degree of probability of death relating to traffic homicides, is the Moore case. The court explained in that case that Mr. Moore, the defendant in that case, drove 70 miles per hour on a neighborhood surface street, intentionally crossed into oncoming opposing traffic, causing other drivers to avoid him, intentionally ran through a red light at speed, struck a car in the intersection at speed without even attempting to apply his brakes, killed a passenger, and then evaded the police following that. And he did all of this, as he admitted, because of what he called, quote, wacky tobacco, end quote. That's a quote right out of the case, reasonably implying that he was high on marijuana.
Wacky tobacco. Amazing.
At the time. The court in that case defined a high probability of death, and this is important, as a near certainty. A near certainty that the act would result in death. That's what a high probability of death means in California. Not that the act possibly could cause death, not that the act probably would cause death, not that the act was dangerous or even highly dangerous, but rather that it's a near certainty that the act alone would cause death. Did the people say or establish in any way at the preliminary hearing that the mere act of speeding on PCH, that's what their postulate is, the mere act of speeding on PCH is nearly certain to cause death. That is absurd. They did not, because they thought it is objectively not true that speeding on PCH nearly always causes death. In fact, it does not, and the people well know it. So that objective factor, and the act claimed by the people as a high probability of causing death, has simply not been met. It wasn't met at the preliminary hearing. Therefore, there is no implied malice to prove this case, or to prove those charges. That is the controlling law in California, and it's simply not the standard that the prosecution applied, and it's not the standard that the magistrate applied, respectfully. The prosecution argued at the preliminary hearing what the magistrate ultimately accepted is the old formulation that an act is sufficient to satisfy the objective requirement if it's dangerous execution. And again, if we were standing here arguing this in 2015 or in 2022 before Reyes, I might not even be making this argument. But here we are in 2025, post-Reyes, and that's no longer the law. Danger is no longer enough. The Supreme Court expressly rejected that diluted standard and replaced it with a far more narrow standard. And that matters in this case. This is that type of case where the law actually makes a difference. The law actually defines what this court can and should do. Because failing the objective prong just ends the inquiry. We're just done. If the act does not objectively involve a high probability.
Yeah, he's got some sort of injury to his hand. I'm not sure what it is.
Probability of death. There is no implied malice, even if the defendant was fully aware of the risk. And in this case, he wasn't, which I'll get to in just a second. The Supreme Court Justice that I referred to earlier, Justice Evans, has already anticipated and warned against the exact mistake that the people are making in this case. She literally saw it coming, the exact arguments that they're making, and warned the lower courts against that argument. In a published statement following Reyes, Supreme Court Justice Evans explained that lower courts in vehicular cases have been ignoring the objective standard, applying an outdated CalPrim language, and treating speed as if it were inherently sufficient to show implied malice. It doesn't get much clearer than that. She stated
Excellent question, Aiden. Excellent question.
Plainly, quote, and this is her quote, not mine, quote, speeding.
I'm like,
even at a high rate.
Homie, I'm on the fence on this one, man. Like, I mean, clearly there shouldn't be a murder charge. I don't believe that there should be a murder charge. No. I'm on the fence of like, is AJ gonna win this one? That's what I'm curious about. I feel like this kid is not doing himself any favors by looking the way that he does.
Does not automatically equate to a high probability of death, end quote. That is not my characterization. That is a sitting California Supreme Court Justice explaining that in vehicular cases, you must apply the Reyes standard, and failing to do so is reversible error. The fact is the people in their entire opposition relied on and stated the wrong law, and the magistrate got the law wrong as well. Justice Evans explained why that outdated law was changed. Why was it changed in the first place? Why are you going to address it? She explained that thousands of Californians drive at excessive speeds every day without causing death. As the justice noted, just as drunk driving does not always or even usually result in death, even speeding. That means speeding, even extreme speeding, cannot be treated as malice per se, which is what the people are asking this court.
I mean, that's some sweet little misdirection there, you know? Because, like, yeah, okay, of course not. Of course, drunk driving doesn't always result in a death. Of course not. Sure. But the thing is like, the argument to that is like, okay, well, that's why people get murder charges and manslaughter charges when they kill somebody with their vehicle and they've been drunk, is because, you know, they knew that they shouldn't have been driving. It impaired their ability to drive. And so, had the person not been drunk, would the person in the accident have survived? You know what I mean? That's the question. But this is a great way of flipping that coin and look at it. AJ's good, man. AJ's good. I love this shit. Let's see. They almost got Karen, and there was no evidence he was hit by a car. Him hitting them with a car is not in dispute. Right. Yeah. No, it's not at all. It's not at all. The question is whether or not it was murder. Like, he's being charged with murder. And it's like, okay, well, he was speeding. Even if he was speeding, how is that not just a manslaughter charge? And they're trying to say that by speeding, he knew he could have killed somebody. So he should have expected that he was going to kill somebody. And yeah, insane. This is fucking wild.
What they asked the magistrate to do. There must be evidence that the act in the circumstances, the actual act in the circumstances presented, had a high probability of actually causing death. And here there is none. Not one witness, not one expert, not one data point, not a study.
So they're almost literally splitting hairs here. Like, it's crazy because they're like, okay, you know, the difference between probability and possibility is the argument here. Like, that's fucking crazy. the difference between they're going to be arguing the difference between probability and possibility. Right. I totally agree. And this no jury is going to like this kid. Like, this kid is sitting there like he's got better things to do. He's swiveling around in his chair. He's got his nose stuck up to everybody. And, you know, he crashed his BMW and he doesn't even seem to give a fuck. Like, you know what I mean? Like, this kid is not winning over a jury. There's no way. Unless AJ just fucking grooms him. You know, unless AJ just sits there and goes, hey, listen, you little asshole, sit up straight, fucking make eye contact with the judge and look attentive. Don't fucking sit there swiveling around in your chair like you should be filming a movie instead of being here. Get the fuck out of here.
No, not one foundation of evidence that driving at X speed for X number of seconds.
He sure did. I talked about that. I talked about that in my members only stream this morning. I talked about that. I was like, yeah, he didn't do that with Karen. So who knows? Maybe part of his strategy is to be like, oh, well, you know, he has nothing to be remorseful for or blah, blah, blah. But bullshit. Like, you need to show some sort of empathy for this victim. In Karen's case, Karen was being framed. Karen had, like, you want Karen to look angry. You want Karen to look like, fuck you, I shouldn't be here. This is fucking ridiculous, and I'm fighting back. You want her to have that demeanor about her. In this case, you want this dude looking as fucking empathetic, looking as remorseful as possible, and it's not happening. So I don't know what AJ's doing. I don't know. Natasha, thank you so much for the super sticker. Appreciate it. I don't know what AJ's doing. Maybe AJ's tired. Maybe AJ's just fucking beat now, bro. Like, he's just exhausted. And I could see Karen not listening to him as well. Yeah, I could see that happening, just being like, no, fuck that. Fuck that. I don't like people playing on my phone.
Try to make that show.
When keeping it real goes wrong.
Because they cannot. They relied instead on outdated jury instruction, and the Supreme Court's already said that's manifest error. And as Justice Evans said, I just indicated, she warned courts, don't do this. Do not do this. The people asking this court to do exactly that. If this court applies the law as it currently exists, discussed it, post-Reyes, the murder counts have to be dismissed. Now we have the correct legal frame. I want to return back to the prosecution's theory.
I think we're both in agreement that AJ did not sign off on that shit. It sure as fuck didn't happen.
The one that relied on opposition papers. At the preliminary hearing, the prosecution's argument was there has to be a number where speed becomes murder. There has to be a number where speed becomes murder. It's undefined. There just has to be one, Your Honor, where speed becomes murder. That was their theory then. They told the magistrate that speed itself was both the objective and the subjective proof of implied malice, and even in their reply papers, they do the same thing today. Objective and subjective determination of the lethality of speed. They're still continuing to make the same legal error. That's not the law. There is no magic number at which speed automatically becomes murder. The law doesn't permit implied malice to be inferred from some undefined mileage per hour or even a defined mileage per hour.
See, that's just good lawyering right there. You know, that's just good lawyering. He's like, well, where's the determined speed that makes it murder? Where's the number? What's the number of miles per hour that determines that this is that goes from it being manslaughter to murder? That goes from it being from an accident to manslaughter, from manslaughter to murder. What's the exact? Where's the law that says that this many miles per what's the miles per hour amount? Oh fuck, you're on fire, bro.
The Supreme Court in Reyes and after Reyes has explicitly warned courts not to collapse those two objective and subjective standards or prongs into one single fact, like, for instance, speed. In the opposition, the people have abandoned their original argument, and they've tried to replace it with something even more legally deficient. The idea that Fraser's general familiarity with the phrase, quote, speed kills, that slogan, proves both knowledge and conscious disregard, because once he heard the slogan, or because one time he may have heard the slogan or saw it somewhere on the side of a bus or a bus bench.
Yeah, that's a reach. That's a reach. What are the circumstances that he said this speed kills? I want to know what that is. Let me hear that one more time.
There's general familiarity with the phrase, quote, speed kills, that slogan, proves both knowledge and conscious disregard, because once he heard the slogan, or because one time he may have heard the slogan or saw it somewhere on the side of a bus or a bus bench. That is not proof of subjective malice.
It's not.
That's proof that the defendant is a human being who's seen the same public safety billboard that you and I have seen and the rest of us, everybody in the audience has seen.
Right, because I suppose the West Memphis 3, since they listened to metal with all kinds of gory ass lyrics and drew pentagrams, that they must have killed those kids in West Memphis, and it must have been a ritual killing, right?
Think about it. If this court, Your Honor, were to uphold the people's improper theory, every time there's a vehicular fatality, pretty much every time, all the officer would need to do is say, have you heard that speed kills? And if the unsuspecting driver says yes, now they're facing murder charges? Implied malice requires the defendant to have actually appreciated the specific danger of his or her act at that time. Not a general awareness that speeding somewhere, sometime, somehow may be dangerous.
Yeah, I was saying that
yesterday. The requirement
yesterday.
is this.
I was saying that yesterday. The only chance they have is producing this fucking road rage driver who, I mean, and proof. Like, I want to see this guy I want to see footage of the guy fucking speeding up, doing some Fast and Furious bullshit, and yelling and screaming out the window like a goddamn Karen, screaming and yelling, talking about, fuck you, blah, blah, blah. I want to see all that shit. Unless that shit happened, this dude is going to fucking jail. No doubt about it. Like, all they have to do, a jury's going to look at him, and a jury's going to look at those 4 families. That dude's going to jail.
The act is nearly certain to kill someone, and I'm going to do it anyway. That's the standard that's set out by the Supreme Court. I know the act I'm about to engage in is nearly certain to kill someone. I'm going to do it anyway. That's implied malice. That's the subjective factor. Nothing in the record comes close to that standard, Your Honor, and the people know that, which is why they're trying to replace evidence with inference and slogans like speed kills. The people also want to rest on the fact that Fraser knew friends who died in an automobile accident at some point in his past. They want to suggest that that's enough for his subjective intent to consciously disregard the near certainty that speeding equals.
I mean, yo. This kid does not look remorseful at all. You put this kid in the same fucking room with a jury and 4 families of dead sorority girls. This guy's going to jail. Like, there's no, that's it. I mean, and I get it. The murder charge, murder's excessive. I agree with that. And that's totally AJ. I'm predicting that AJ's going to try to come up with a plea deal. I don't think that AJ thinks that he can win this in trial court. I don't think that there's no way. I don't think AJ thinks that he can win this. Look at this kid. Like you see the shit in the movies.
Bro, we all likely know someone tragically.
The kid has fucking permanent duck lips, dude. The guy looks like he's posing for a Tinder profile right now. So I think AJ's going to try to plea it down, try to get no jail time, but this kid's going to jail. This kid's fucking totally. The question is whether he's going to jail for the rest of his life or going to jail for like 20 years. That's the question.
Through his past in some sort of traffic accident. I'll bet if I asked for a showing of hands in this courtroom, very few wouldn't go up if I said, do you know someone or know someone who knew someone who tragically passed in a traffic accident? But under the law, that's not the same as being sensitized to the consequences of certain acts. That's what the law requires. We have yet to find any case in all our research.
It doesn't matter if you disagree with me. It matters if a jury sees him the way that I do. And I'm telling you that the chances are they will.
In which that was the predicate for the subjective requirement. And yet every case that we have found, including Ortiz, which we cited, states the opposite. The subjective requirement can be established only from suffering serious consequences from the government because of your own conduct. That's Watson. This court knows that case inside and out. That's Watson. The defendant has suffered sanctions by the government, warnings by the government in judicial proceedings, in a judicial governmental environment that warned him against the very act he then went out and did again. That is missing here. The people cannot replace Fraser's subjective knowledge with a traffic slogan and somebody else's traffic collision. That's not the law. The court has never done it, and I seriously doubt that this court wants to be the first. Thus, the prosecution cannot satisfy the subjective component either of murder or implied malice. There's no evidence, none, that Fraser believed he was actually traveling at 100 miles an hour, or 90 miles an hour, or 80 miles an hour. There's no evidence of that in the record.
See, that's a stretch too, dude, because like obviously he was going fast enough to kill 4 girls. Fast enough to crash into 3 cars and kill 4 people. So AJ, come on, bro. Like you're come on.
Whatsoever. The unrefuted evidence of what was subjectively in Fraser's mind is, the court read the transcripts, I don't know, when asked over and over and over, how fast were you going? He said, I don't know. If Fraser did not know his speed, then clearly he could not have consciously disregarded a danger he didn't perceive. The Supreme Court has repeatedly said, you can't disregard a fact you don't know. Further, unlike in the Moore case, which I cited to the court a little bit earlier, and Gonzalez, which is in our papers, where the defendants admitted that they knew that what they were doing had a high probability of death, and they didn't care. They knew exactly what they were doing in both of those cases. The defendants in both of those cases said, I don't care. There's no evidence that Fraser knew what he was doing, was, quote, nearly certain, end quote, to kill anyone, a high probability of death.
Nobody wears a sign around their neck saying, my intent is to do this. My knowledge is so-and-so. It has to be judged by their actions and by the totality of the circumstances, doesn't it? Nobody comes out and says, my intention is to kill somebody when they point a gun at someone. My intention is to kill you. Nobody said that. You have to base your judgment as to what their intent was and their knowledge on their actions and on the circumstances surrounding it.
I mean, okay, Coffee House Crawford with a judge's fucking robe. Like, you're talking about apples and oranges here, though. You're talking about the circumstances of somebody driving a car versus somebody pointing a fucking gun. What are you talking about? Like, it's not even apples and oranges. It's fucking apples and bulldozers. What are you talking about? Like, that's just crazy. Like, you're talking about a car accident versus somebody getting shot. What are you talking about, dude?
Circumstantial evidence has to be used to a certain degree. Absolutely, I agree with that. Nobody wears the sign under that, saying I intend to do this. But in every case in which that subjective knowledge has been imputed to a defendant, in every case, Ortiz, Canizales, Moore, all those cases have evidence in the record that the defendant knew what he was doing had a high probability of death and then ignored it, intentionally ignored it, through his statements, through his conduct after the fact, through fleeing after the fact, trying to avoid prosecution after the fact, saying, I knew I was going to go through the intersection. In Moore, for God's sake, the man drove through an intersection, killed a pedestrian, drove home, then said, when the officer said, well, you know what you did, didn't you? And he said, yeah, I think I cut the guy in half. It was disgusting. And there was subsequent post-conduct comments by all of those defendants to suggest they knew what they were doing and didn't care about it. That's the inferential evidence that was used in those cases, and that's what I'm highlighting to the court that we don't have with Fraser. He didn't know how fast he was going. He did not have that information.
That post-accident conduct, as disgusting as it was a factor, but it wasn't in and of itself determinative.
It was a factor that they used in addition to the other factors to indicate inferentially that they knew that their conduct of that speeding on surface streets, high rate of speed, going through an intersection, etc., was inherently dangerous to a point that it was in that, as the jury instruction says, in that there was a high probability of causing death. That's what's missing, Your Honor. The court is exactly right in highlighting this. Of course, nobody's going to wear a sign or send a voicemail saying, I know what I'm about to do is nearly certain to cause death. The problem with the prosecution's case and the magistrate's holding order is that there's no evidence. The record is completely deplete of evidence that Fraser knew how fast he was going. That's why I was saying,
how would somebody driving 100 miles an hour or 90 or whatever the speed actually was up in that range not know that you're going super fast? How would you not know that? Really?
Super fast is not the standard.
No. But that's my question. If you're driving a car 95 miles an hour, you know you're not driving 40. Am I wrong about that?
You're not wrong about that. But speed alone is not.
I understand that.
Speed alone is not. It's not enough.
But to gauge a person's knowledge of what it is that they're doing, the consciousness of it, you have to use common sense as well. And I'm sorry, when you're driving 95 miles an hour, 100 miles an hour, you know you're driving extremely fast. You know that.
If other cars are driving,
that judge is totally afraid to go fast, bro. You know that judge drives a fucking Subaru, and like, you know, he drives a fucking Subaru, and he's just like, if you're not going 30, well, then you're trying to kill people. Like, calm down, bro. Relax. You know, let your hair blow in the wind.
70, 75, 80 on Pacific Coast Highway. Which owner they do all the time. I mean, now we're just talking about perception, right? Now we're talking about the court's perception. You must perceive that you're going fast. I was on that road 2 weeks ago. There were sports cars passing me. I was going 70. By the way, that was above the speed limit. Didn't realize it because every car next to me was even going the same.
During I'm so genuine, Your Honor. I am so genuine that I will admit to committing a crime in making this argument, Your Honor. I love AJ so much, bro.
Speed or going faster than me. It's a perception issue. It's not like he was going 70 or 80 or 90 miles an hour, whatever the speed is, which the prosecution cannot find in a 25 mile an hour zone right next to a school. He's on PCH, and other cars are going similar speeds. Yes, he may have been going faster than the cars next to him, but not to a degree that it's a near certainty to cause death.
Well,
and that's the point at which it would have to be.
I'm going to discuss what the underlying facts of the case, but just as a preview, all of the evidence from the civilian witnesses in the case.
Bro, I bet you that judge has fucking like power crystals under his robe and shit. Like he's got like some blessed quartz hanging around his neck and shit. He's got sage burning in his fucking chambers.
The defendant zoomed away far faster. They couldn't even come close to saying whether he was driving so fast. He was hundreds of yards ahead at the time of the
witnesses, not a single witness at the preliminary hearing put him going 100 miles an hour. Not a single one. As a matter of fact, the witnesses that were asked how fast do you think he was going, they estimated him going around 70. That was in the preliminary hearing transcript. I went there. That's what they said. That is not extraordinary, and certainly that's not enough to suggest a near certainty that someone is going to die. It's just not enough. I don't want to get spun into a discussion or even an argument, certainly with the court, about was it dangerous? We can all agree speeding is dangerous. We can all agree that it has a possibility of causing death or great bodily injury. We can all agree with that. That's not the law.
Can we agree that the faster you're going, the more likely it is to cause death?
Depends on how fast
The judge became a Reiki master just to get chicks.
you're going. Absolutely depends on how fast you're going. We can all agree on this. According to Justice Evans, that's not enough.
Right.
That is not enough by itself. And that's the only thing the prosecution has. Speeding. That's it. And that's notable. The people routinely charge vehicular manslaughter, not murder, just as the court is discussing in fatal speeding cases, unless there's clear evidence of the subjective knowledge. 2 weeks ago, to the court's point, 2 weeks ago, maybe not 2 weeks ago today, maybe it's 14 days, 15 days, 13 days ago. It was October 25th. This same office filed manslaughter charges in a case called People versus Kirksey. The driver was speeding on surface streets, drove onto the sidewalk, struck and killed 2 pedestrians, severely injured 2 others, then fled the scene, then fled the jurisdiction. He was finally caught in Chicago 2 weeks ago. Killed 2 pedestrians, injured 2 others, fled the jurisdiction, and fled for the specific purpose of avoiding prosecution. Manslaughter. They didn't even approach murder charges in that case. If the law is anything, it's got to be deliberate. Fraser, by contrast, as established in the facts of the preliminary hearing, stayed at the scene, cooperated with investigators, no drugs, no alcohol on board, no driving history, no fleeing, no secondary criminal act, all of which this other case had. Like I said, if the law is anything, it has to be deliberated, and it has to be consistent. And that means that similar facts should produce similar charges. And less aggravated facts should never be charged more severely. Selective charging is not just unfair, Judge, as this court knows, it's unconstitutional.
Well,
here, there's not even evidence that Fraser intended to drive fast for its own sake.
My man AJ leaned in there. He said, not only unjust, it's unconstitutional. Fuck yeah, get him, AJ. Get that Reiki judge. Reikio, whatever the fuck. Are you sure it's necessary that my top is off? I'm not going to touch you, but in order to get a proper connection with your chi, there can't be any obstructions. Fucking dirtbag judge.
Every available piece of evidence supports the opposite, that he was reacting to events unfolding in the moment, including being chased, being clipped by another vehicle seconds before impact. That is not malice. I'm not arguing that it wasn't dangerous. That's not the law. The law is for malice. It has to be a near certainty to cause death, and he has to subjectively say, I know it, and I don't care. That's their burden. What we have before us is instinct, not intent, not subjective intent. This was not malice. This was an accident. Perhaps negligence, not murder. The people now argue in their papers that the cause of the crash, astonishingly, is irrelevant. That doesn't change his culpability. Let me say that again. The cause of the crash is irrelevant. Your Honor, this is a murder case. Causation is everything. If Fraser was clipped or swerved or reacted to external events, that his act was not the probable cause of death. That alone defeats the murder charge and the people's own exhibits.
Yeah, is the fucking prosecution trying to say that what? Hold on a second. Let me hear that one more time.
Is irrelevant. That the cause of the crash, astonishingly, is irrelevant.
How could I'm with AJ on that one. How could the prosecution try to say that the cause of the crash is irrelevant? That's like saying that the cause of John O'Keefe's injuries is irrelevant. Like, we knew that it was relevant. They tried to say that it was a vehicle. And since they proved that a vehicle didn't strike John O'Keefe, well then, case closed. She didn't do it. So, of course, the cause of the accident is relevant. Of course it is.
That doesn't change his culpability. Let me say that again. The cause of the crash is irrelevant. Your Honor, this is a murder case. Causation is everything. If Fraser was clipped or swerved or reacted to external events, that his act was not the probable cause of death. That alone defeats the murder charge, and the people's own exhibits show driver's side contact with his car, white paint transfer, matching the damage to Miss Ortiz's vehicle. The very facts that the prosecution sort of wants to pretend doesn't exist. And you cannot argue implied malice when the defendant's conduct was reactive rather than intentional. Your Honor, Section 995 exists for exactly this reason, to purge charges that sound regular but rest on legally unsupported theories. The Supreme Court has repeatedly instructed that a 995 motion must be granted when the magistrate applied the wrong legal standard, not just where the evidence is weak, but where the governing law and the governing elements were misapplied. And that's what happened in this case. It's precisely what happened here. Judge Edward did not get the law right. He accepted that there must be a number, there must be a speed theory, and that's legal error. The people continue to cite to the court outdated law, and that is legal error. The controlling standard for the objective requirement has never been met, and that's legal error. Once the right law is applied, the outcome is no longer discretionary for this court. It's not even close. It's not debatable. It's mandatory. If Reyes governs, and Reyes does, I think we're all in agreement, including Mr. Parker, that Reyes now governs. If the current CalCrim 520, which I placed on the court's bench, governs, again, we're all in agreement that it does govern, then the murder counts must be dismissed. The case comes down to this, and my closing comments are these. There's one unavoidable question. Did the prosecution present evidence that Fraser Bohm committed an act involving a high probability of death at the time? that he knew it and that he intentionally disregarded it? The answer is no. Not a little bit, not barely, not depending on how you look at it. The answer is just no.
The answer is
No
just
intoxication, no racing, no tests, no statements of indifference, no prior warnings, no subjective awareness, no prior serious consequences by the government, no bad driving in his history, ever. And no objective showing of a high probability of death to a near certainty. Just speed, and speed is not malice. Section 995 is that safety valve, the safety valve that every member of the community relies on. It prevents exactly this kind of overreach. And the law demands that the murder counts be dismissed so that this case can proceed on the proper charges. The charges the evidence actually supports. Manslaughter, not murder. We ask the court to dismiss counts 1 through 4.
Like, I'm really looking forward to hearing the rebuttal from the prosecution on that.
Thank you.
Thank you. The defense points out the change in California 520, including the language of high probability.
Dude, did these guys go to college at the same fucking commune? The fuck is going on with the prosecution and the judge? Why do they look like they just came from a fucking Fish concert? It's so weird. Window Bailey, thank you so much. If speeding is attempted murder, we are all guilty. If speeding causes a wreck, it's murder. No way will Fraser be found guilty, in my opinion. Yeah, I mean, I don't know, man. Like, I agree with you that he shouldn't be, but the problem is the kid is sitting there looking like he's about to shoot a fucking Naughty America, My Best Friend's Mom porn. Like, you know, nobody fucking likes that shit. Nobody can relate to the kid. You know what I mean? Like, nobody likes it. Like, I'm just telling you, nobody likes that shit. Fucking. Oh, hey, I just came by to pick up one of Hunter's books, Miss Brandy. Oh, you did? Oh, well, he's not here right now. You could come in and have a seat. I've seen you looking at my breasts. Jesus Christ, dude. Oh, Miss Brandy. What if Hunter comes home?
So, if they just ask a question, if the people presented that at preliminary hearing. Well, it appears that the judge who held the defendant to answer believes so, when in his holding he said, quote, implied malice requires that the defendant act with a wanton disregard of a high probability of death. That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15. The committing magistrate clearly understood the law and applied the law to the facts that he heard. And we're here for a 995 motion. And the question then is...
It's the lawyer who stares at goats.
Were there sufficient acts for him to draw that conclusion? Understand, he was applying the very law the counsel's been saying he did. I did want to note one thing in terms of the high probability. One of the cases cited by the defense was People v. Pierce at 114 Cal App 5th 508. And in Pierce, they confirm that there has not been a fundamental change to the law. They say, quote, finally, we know that the defense contends the high...
I feel like this guy just came from Denzel Washington's hospital room and was like, I got you a big old line of cocaine, buddy.
Yes! I like it.
We're going to take the choo-choo train, buddy.
Court in Reyes, quote, changed its position on the objective component of implied malice and redefined dangerous to human life as requiring a high probability that the defendant's act would result in death. Contrary to the defendant's argument, the requirement that an act carry, quote, a high probability of death is not new, and Reyes itself noted the equivalence of the Thomas and Phillips formulations, those which came before, restating that the language that already existed stood for the same thing. This is a refinement of the language. And in fact, in the Pierce case,
520 have to be changed.
Like Kelsey wears fucking orthopedic shoes to court. This guy wears fucking Birkenstocks. Fucking goes to Christmas present over here, bro.
no, because it's stating that this already exists, that this is not new. This is the formulation. The change of 520 was a refinement in the language. The standard has always been that the failure to act, even from the previous language, the natural and probable consequences of the were dangerous to human life.
That's not the same. That's not as stringent as the requirement.
It is.
I loved when Braveheart knocked this dude out with a pebble, bro.
It's different language, but the point was that that was the language that was provided to, in this case, a jury. And the court upheld the conviction, stating that the language was sufficient based on what was provided to the jury at the time. So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed.
AJ's like, you might want to not sit there and look like a fucking douchebag this whole time. And like, if you want to go to jail for the rest of your life, do what I fucking tell you and quit swiveling in your chair, you little shit.
In isolation is not the determination. Watson and all of his progeny, again and again, they don't provide any definition of what implied malice is. They talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant was driving down an open road with no other vehicles, with no other cars, pedestrians, just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that stretch of stage, which the defendant said that he was familiar with.
This aggression will not stand, man.
Doesn't have sidewalks. This was all information known to the defendant at the time that he decided to engage in the behavior that he did. The speed that we're talking about has to be looked at in terms of where he was and what he was doing. It isn't just that he reached the speeds that he did. He also had to navigate around other vehicles that were going slower. And that evidence was presented at the preliminary hearing. And that he went around because, even according to him, the vehicle in front of him was in his lane, so he drove around. And that's when he was reaching those high speeds. He claimed that vehicle then started to merge into his lane. So first, let me talk about that in terms of my moving paper saying that about the cause of the accident. The defendant's conduct was the proximate cause of the accident, or the collision, I should say.
I mean, right.
There is not evidence presented at preliminary hearing or anywhere else other than the defendant's statement that there was any contact between the defendant's vehicle and another. And the physical evidence shows that did not occur. I don't understand where
The mirror was running.
the mirror was.
It was out of place.
It was out of place. The mirror was out of place in a position that one would not expect to have happened if it occurred while the defendant was passing another vehicle. One would anticipate the mirror would be knocked back as it struck, as it's moving forward, and it would be knocked backwards. The defendant's error was not forward. And that was after he had exited his vehicle. I could not say exactly how that occurred, but it does not appear that it would have come from striking that other vehicle. And certainly being the fact that the other vehicle suffered no damage on its mirror. The important point then is that
the important point is, Your Honor, the doors of perception allow all kinds of different possibilities, man. I mean, you go through one door, man, and it was an accident, and then like you go through another door, man, and then it's like, whoa, it's murder.
this other vehicle is part of the issues that the defendant faces when he gets his vehicle up to the speeds that he did, because people change lanes. And if the defendant is attempting to pass on the right at speeds of 104 miles an hour, and the vehicle starts to turn, he does not have sufficient time in order to control his vehicle. And I did want to point out that the one thing that the defense didn't talk about was the fact that the defendant said when that vehicle came into his lane, he swerved to avoid it. We had the electronic data from the airbag system, and that was presented and put into evidence, and there was no swerving to what would be the light to the right.
I found footage of when this guy decided to go to law school. I found
footage.
footage.
The only steering inputs at all were to the left, contrary to what the defendant said.
It's yours?
No,
My mother said she found it in your closet.
I don't know. One of the guys must
Must have what?
Look, Dad, it's
Where
not.
did you get it?
Dad,
Answer me. Who taught you how to do this stuff?
You, all right? I learned it by watching you.
Parents who use drugs have children who use drugs.
There it is, man. There it is. Now you know. That was the day. He was like, I should have won that argument with my dad.
And as I noted in my moving papers, and I won't go into great detail, but it does show that the defendant understood that what he was doing was dangerous, and he is coming up with excuses as to why the collision. The other important factor about the speed and the electronic data control is that at the outset of its recording, which occurred 5 seconds prior to the first deployment of an airbag.
Make sure you guys subscribe to Court Chopped, and make sure to like this video that I'm playing here. Here, I'll post it again. Make sure to hit the like on this.
And some 7 seconds before the final deployment. Those inputs included an engagement of the stability control system, meaning the vehicle was not stable in its movement. In fact, we heard testimony at the preliminary hearing from Miguel.
I mean, all of this sounds like an accident to me, bro.
Chino, that he observed the defendant's vehicle skid, lose traction with the road as he saw
Broken Baker and his peeps are in the house, folks.
it then speed off. He said he could see the puff of smoke. According to the electronic data, that occurred when the defendant was doing 93 miles an hour and had his accelerator at 79%. He continued to accelerate for another 4 seconds after the vehicle lost traction with the road. As the court said, this isn't just he's going faster and doesn't notice, as Mr. Jackson said. He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above the limit, and continues on to what the data reported as 104 miles an hour. How could he not have known In regards to the defense saying that we are relying simply on a slogan to prove that the defendant had subjective knowledge of the dangers of his speeding.
The biggest
It was
flaw,
the defendant himself.
the biggest flaw with this murder charge is like, okay, so was he trying to kill himself too? You know what I mean? Like, he's in the car, he's using his car as a murder weapon, but he's in the car. Are you telling me that he was trying to sacrifice himself? Was it an attempted murder suicide? You're telling me that this guy intended to crash into these three vehicles and then walk away from it? That's what he intended to do? The fuck out of here. Like, you can't have one without the other, bro. Like, you're saying that he intended on killing these people. He had to have known. Well, then he must have known that he could have died too. So you're saying that he attempted suicide as well?
In the statement, who turned the slogan into something personal to him. That he had two of his best friends die as a result of speed. The defendant had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that the speed, and he said that he believed it was.
You gotta know how stupid you sound, dude. You've gotta know that you sound fucking baked, bro, and like out of your mind.
130 miles an hour caused the death of his two best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty.
Could result in death. Could result in death. Okay.
It is more than remote, or and I want to get the language right. In one of the citations, and this is from Reyes, citing People Deep Ravens, the quote from concurrence of Justice Liu, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive, we're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%. And as the court noted this isn't just about the speed. It's about his knowledge and about where he is engaging in this excessive speed. And he said he knows PCH like the back of his hand. And he knows it like the back of his hand. He knows that people are putting out their trash cans. He knows that people are parallel parking. He knows that people cross on the crosswalk that is demonstrated in the exhibits that the defendant passed as part of his path towards where the collision took place. He knows this, and yet with that knowledge, with the knowledge that he is already losing control of his vehicle due to the speed, he continues to press down that accelerator for another 4 seconds. And that totality is the basis that the magistrate used to hold the defendant to answer. It is not that there has been no evidence, it's not that there has been an abundance of evidence.
This guy's such a fucking douche, man. No wonder Helen of Troy left your ass.
More so than is needed. But the point is, at this hearing, it's whether that evidence was presented sufficient for the magistrate to hold the defendant to answer, and it was.
Very briefly, first of all, first thing I want to mention is that the math is wrong.
The math is wrong.
230%. The math is wrong. The speed limit was 45 or 50. 230% would be 145 miles an hour. That's absurd. 100% is double. 100% on top of that.
Right.
The 45 again. So
Even I
right.
can get that math right.
Was he speeding? Sure. But I don't want to get ridiculous about this. 230 times. I want to know what the hell was he doing? Jet? You got the math.
I don't want to get fucking ridiculous about it here, bro. He just like, hey, let's just keep this shit in perspective here, okay? Let's not get fucking crazy. 230 times the speed limit, dude. Please, bro. The fuck are you talking about? Is he fucking flying a jet? Like, are you kidding? Like, the DeLorean takes less than that to travel back in time. Stop it.
Let's talk about facts. Provable facts. Mr. Bartos says he was speeding. Okay, that's in a bucket. He's been saying that from day one. He's searching, and the prosecution has been searching and grasping at straws for anything other than that.
I mean, yeah, that's what I'm getting out of that.
Beside the PCH. That's dangerous. There are driveways leading out to PCH. That's also dangerous. There's cars parked along PCH. Boy, that's dangerous. There are trash cans. People have to put their trash cans out. That's dangerous. There's no sidewalks, and yet there's still pedestrians across the street. It's also dangerous. He went around some slower traffic, so says Mr. Bartos. Is that dangerous? Maybe not. And
there's a fucking armadillo crossing the street. That's fucking dangerous.
At a higher rate of speed gives you less time to react. It's also dangerous. Where in that list did Mr. Bartos establish?
He knew it was trash day. He knew it was trash day. He must have wanted to kill somebody. Get the fuck out of here.
High probability of death. That's the standard. The prosecution has gotten into this spin cycle non-stop since the preliminary hearing. Well, this was dangerous. This seemed dangerous. This is dangerous. This is dangerous. That's not the law. As the court rightly termed, the jury instruction, it was changed for a reason. The Pierce case didn't stand for the proposition that it's all the same. It's always been a high probability of death. That's not true. The Reyes case changed the law, and the jury instruction was changed because of that, as the court noted. We are not talking about something that's dangerous. Is excessive speed dangerous?
Did he already get the tacos? Was he on his way back from the taco place, or was he on his way to get the tacos when the accident happened? I'm curious about that. Anybody know? Anyone? He got them. He had the tacos. Okay. He got the tacos. So you tell me who in their fucking right mind is like, yo, I just got a shit ton of tacos. Dude, I would be so stoked to be eating those tacos. If I'm speeding, it's because I can't wait to eat the tacos. Not because I'm trying to kill people and I got to watch the fucking tacos fucking sit in my car as I'm getting handcuffed and fucking taken away. You know what I'm saying? Like, I want those goddamn tacos, dude. I want some tacos right now. Now, would I put lives in danger to get those tacos? Depending on how hungry I am. I'm not at taco want level kill just yet. I'm not there yet. But I mean, you can't have intention to eat tacos and intention to kill people at the same time. Doesn't happen, bro. Doesn't happen. Dude wants to eat his tacos. Like he had motive in the car to not kill anybody. Because Kelsey G, specially appointed prosecutor Robert Cosgrove, as any woman on Tinder will tell you, tacos are life.
We go out on Van Nuys Boulevard, whatever the big boulevard is, Van Nuys Boulevard, outside the courthouse. How many folks are going to be speeding on that road? Just, we can look for 10 minutes. How many folks are going to be speeding on that road? Nearly all. Nearly all. It's California, for God's sake.
I don't like the way you're talking about that.
Fair enough. Fair enough. I'm making the point, but I don't mean to upset a community, but I'm making the point that speeding can be dangerous, probably is dangerous, but it doesn't in and of itself reflect a high probability of death.
What circumstances would, in your mind, represent a driving death?
It merely represents a possibility.
If he was high.
But it was like, whether you're high, you're drunk, or whatever it might be, equally, and you're therefore likely to cause some kind of accident. Who's to say whether this accident with drugs or that accident without drugs is more likely to happen to hit a vehicle or a pedestrian and kill them?
That's a great question, Your Honor. But that's up to the prosecution to answer because the burden of proof is on them. That's not my fucking place to fucking tell you that. The fuck? I don't give a, I'm not here to sit there and give you I'm not here to give you probabilities on whether it's a higher probability of somebody getting in an accident, whether they're high, drunk, blah, blah, blah. The fact of the matter is that my client wasn't high or drunk or under the influence of anything other than a want to put tacos in his face. That's it. Nothing else. A desire to stuff his face with fucking tacos. That's what he was high on. That's not up to me. Ask Lebowski over here whether or not these are things that he should be thinking about and whether it matters. What are you talking about?
There's a circumstance in which
Isn't there a large degree of bad luck?
Luck is not enough. It has to be, yes. Sometimes accidents always happen to a certain degree because of bad luck. But the question becomes, when is it elevated to murder? That's why manslaughter exists, Judge.
So the judge is putting out luck as a factor in this, and you realize this is a fucking murder case, right, Judge? The fuck are you talking about, luck?
That's exactly what you're explaining is why manslaughter exists. Because sometimes people are doing things that are inherently dangerous, that shouldn't be doing it. It costs somebody their life. In every manslaughter case, it's important to reflect that I'm not standing up here asking that the entire case be dismissed. I'm saying let's call it what it is. In every single manslaughter case.
He's not. It is a motion to dismiss, but I'd like to read the motion, honestly. I really want to read that motion, actually. But it's a motion to dismiss the murder charge. He's saying, we'll take a fucking manslaughter charge. That's fine. Whatever. And then we'll fight that. We'll cross that bridge when we get there. But this isn't murder. Period. This is just not murder. Maine Rescue Dog Mama, thank you so much. Here's to help fund your trip to Boston to say, I love the daily Clubber walks and you have gorgeous eyes. Oh, thanks so much. I appreciate that. That's really nice.
Someone died. By definition, someone lost their life. If what Mr. Bartos is saying is right, basically, the car has a system on it that engaged. It was a traction control system. The car's telling him what he's doing is just about to lose control of the car. Well, first of all, that's not how traction control systems work. There's a beep that goes off or a light that goes off on the dashboard. You never hear it. I've got traction control in one of my cars, and you never know that it's going off or isn't. It's embedded in the EDR system, but it's not tapping the driver on the shoulder and saying, hey, slow down. That's not how it works. The question to answer the court's, the answer to the court's question is, what would show a high probability of death? Street racing. You have 100 miles an hour on surface streets. High probability of death.
Not like that anymore.
Because street racing
cause death than just driving.
Now, here's where that gets tricky. Okay, street racing would cause a high probability of death. Okay, but what if you're going just as fast as any street racer? That's the question, right? Why is street racing? Why can you catch a murder charge if you kill somebody via street racing? Because street racing's illegal, because you're knowingly speeding. So this is the argument that the prosecution is trying to say is, okay, well, if the same actions to street racing apply, then why wouldn't it bring the same punishment? Why wouldn't it bring the same consequences? So,
because street racing by definition is competitive, and you're constantly trying to outperform the other car. It's coordinated, and you're intending to go as fast as your car will possibly take you. That's the point of street racing. Street takeovers, where you're doing donuts.
see, this is bad. This is bad because he's sitting here saying, I mean, it's only plausible because they can't come up with a solid speed. They're saying 104 miles per hour, but there's no science to base that, supposedly. There's no way to actually prove that he was going 104 miles per hour. But, I mean, if he was speeding, he had to know that he was speeding, especially on such a dangerous road. And he probably got some sort of thrill from speeding down that road. I remember when I was a kid, I got fucking borderline car sick because I was riding with my stepfather, and we rode from Miami to Charleston, West Virginia. And he was so excited to take the back roads. Like, he loved to drive, my stepfather. And he was so excited to take the back roads instead of sticking to the highway. And it took us fucking so much longer. And we were just fucking going, and and he was looking forward to it the whole time. And I was just sitting there going, fuck, this sucks. Can't we just get on the fucking highway, dude? Like, this is ridiculous. But he was enjoying those side roads along the side of the mountain where I'm looking at the edge and I'm thinking, holy fuck, we could go over that edge at any given fucking moment. There's no railing to hold us here, nothing. Just ditches right along my side where I'm like, ah. But he got a thrill from driving fast along those streets. So it's quite possible that this kid is like, oh, well, this is a fucking dangerous road. I know it's a dangerous road, and I could fucking rock this road with my dope ass BMW. I mean, that is not a stretch by any means when it comes to a kid sitting in that courtroom looking like that. I mean, let's just be real. At least not in the jury's eyes.
Pedestrians. Nearly every one of those cases that's prosecuted, if a pedestrian gets clipped by a car drifting in circles, gets clipped and gets killed, nearly every one of those cases is prosecuted as a murder. Why? Because it's not just excessive speed, it's losing control of the car on purpose with a pedestrian standing 5.
Not on purpose.
Drifting is losing control of the car going out of sorts. In other words, driving in the manner in which it was not designed to be driven.
Yeah,
it's drifting.
I know I said that, and then I saw footage of the road, so I am corrected on that. It doesn't have a cliff. It's not, there's houses and then there's ocean. Like, it's not like that. I already know, but thank you.
By definition. So you have far less control. No car is designed specifically for that. It has to be in the hands of a professional. So these street takeovers, they kill people all the time. And normally those are prosecuted as murder cases. Why? Because it has the added effect. You're not just speeding like on the 405 to get around slower traffic, driving on a sidewalk, driving when you're evading police. There's always an additive to just speed. That's what Justice Evans was saying.
What about the environment? And Mr. Barker sort of touched on an example that I was gonna.
What about the environment? Shut up.
Raise as well, which is, don't you have to consider the environment and the circumstances? There's a difference in the risk of death in driving 100 on PCH versus, some, far out, desert road where you're on a straightaway, there's no other cars and nobody's around and you can just go 100 and not have to turn the wheel. There's a difference between that and driving on a dangerous crowded road like PCH, isn't there?
They're both dangerous, but neither one of those, by just driving fast alone, neither one of those include a high probability.
This judge looks like he's been a fucking scientist at Area 51 for like the past fucking 40 years. And it's just like, oh my God, I'm so excited because we saw movement in the alien. This is a really exciting time. Running around eating Ben and Jerry's and shit.
Death. People do it every day, Judge. On PCH, they do it every day and no one dies. It doesn't include a high probability of death. This is an incredibly high burden. We're not saying that it wasn't dangerous. I'm not suggesting that there wasn't a possibility that someone could get hurt. I'm saying that there was not a high probability of death such that Fraser Bohm should be saddled with murder charges. These are the same charges that Brian Coburger is facing. That's the point. Brian Coburger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood. Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt?
Yeah.
He did.
Coburger still got a plea deal.
Get hurt. So clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it.
And they have to prove that. Not only all of that shit that AJ just said, but they also have to fucking prove it.
I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. But it wasn't.
No.
Thank you.
Thank you. Any response to that, Mr. Barker?
Hey, John the Sharks. Fuck you.
Here within the evidence was sufficient for the magistrate, and he was correctly applying the facts to the correct law. Anything beyond that would be this court using its own decision making, which is not. It's simply the determination whether there was evidence presented on which the magistrate could rely, and there was.
Just a minute. Your Honor, thank you. So first of all, Church Council is aware is on the record made that standard 4995 motion for the Ride House, the Superior Court case 67, Cal Sec 471. Reasonable probable cause is shown if a man of ordinary caution or prudence would be led to believe and conscientiously entertain a strong suspicion of the guilt of the accused. That's the magistrate's job. The Mandela case, 1983, 33 Cal 3rd, 754, reaffirms that the magistrate's finding of probable stand is supported by any rational interpretation of the evidence. If there is some evidence supporting The magistrate's conclusion, the information will not be set aside some evidence. People versus Superior Court, Decker, 2007 case, California Supreme Court case.
Does he use the same hair products as Krusty Panties?
The reviewing court asked whether the evidence provides a rational basis for believing the defendant could be guilty of the charged crime. Every legitimate inference that may be drawn from the evidence must be drawn in favor of the information. The judge, in my position, is not to reweigh the evidence or judge the credibility of witnesses. At the 995, the question is whether there was simply probable cause to hold the defendant to answer, and that's all. So I'm going to discuss the facts here, and then I will discuss the law that applies to counts 1 through 4. There's no doubt the defendant was driving extremely fast. PCH, all the witnesses described it. They put different numbers on it, but they all said things like he was going, quote, extremely fast, or he, quote, flew past me, or he was going, quote, super fast, or that he, quote, accelerated extensively. The data recorder in Mr. Bohm's car says he was doing close to or even above 100 miles per hour in the instance before.
I didn't know Al Snow went to law school.
Crash in a 45 zone. The magistrate noted the data recorder evidence carried weight in his decision making, acknowledging that warnings that come with it that say it can make mistakes. There was no evidence presented at the preliminary hearing in this case that it made errors here. Defense said Mr. Bohm was fleeing a road rage incident with Mr. Victor Calandra, but there's no evidence of that in the record. The evidence in the record was that Mr. Calandra, when stopped next to the defendant at a light a few moments before the crash, rolled down his window and warned the defendant he needed to be careful, yelling at him, "You need to be more careful, you're going to hurt yourself." Mr. Bohm did not respond. On cross-examination at the prelim, Mr. Calandra said he also included "slow down." He also said he might have said, "You're going to hurt yourself or someone." He said those things because he had seen the way the defendant was driving prior to stopping at that light. He testified the defendant was driving erratically and drifting extensively and speeding. Why else would he say those things to Mr. Bohm if he hadn't seen him driving in such a dangerous manner? That does not sound like road rage to me. The defendant did not even react to Mr. Calandra. Well, the defendant.
Okay, so the road rage guy is saying that instead of having road rage, I didn't have any road rage. I was telling him to slow the fuck down. He's going to hurt somebody or himself. I was trying to warn him, which I was wondering about. If that's the case, this kid is fucked. This kid is going to jail.
From the light, he zoomed away from Mr. Calandra, and there's no evidence that Mr. Calandra accelerated in any attempt to keep up with him and chase him. The attempt to back this as a theory of the case with evidence of a prior incident that Mr. Calandra was involved in did not succeed freely, as Mr. Calandra's testimony was that in that prior incident, the other driver pulled him out of the vehicle and attacked him. Maybe other evidence will be discovered or developed so that this case goes forward, or maybe not. But the testimony that the preliminary hearing in this case was Mr. Calandra's recounting of it, and that involved. Defense also argues there's evidence that his driver's side mirror was hit somehow during this incident by a white car. Mr. Calandra's truck was bright blue. And that I think the argument is intended to be the contact with a white car was somehow causal of this crash. There is evidence that the mirror was damaged. The Ortiz sisters were both driving white vehicles, but neither said they had any contact with the defendant's vehicle. And both said the defendant zoomed off from the light and was way, way, way ahead of them at the time of the crash. This would undermine any causality if there was contact between one of those white vehicles and Mr. Bohm's vehicle. Mr. Calandra also said the defendant was several hundred yards ahead of him at the time of the crash, and his speed was excessive, at one point saying 80, 85 miles an hour, and he did tell the detective it was maybe 70. Mr. I'm mispronouncing it, Scuccino, said the defendant passed the white cars, was going very fast, and was perhaps as much as 600 meters ahead at the time he swerved and then the crash happened. No matter who's more accurate, it's clear that the defendant was far, far ahead of all those other cars at the time he lost control of his vehicle, even if he had previously bumped into one of those cars and damaged his mirror. But there's really no evidence or no testimony that that happened.
All right, blah, blah, blah.
Whether the case will be proven, the murder case will be proven beyond a reasonable doubt, or whether it won't, nobody knows the answer to that. But that's not a question for today. The question for today is whether there was sufficient evidence for the magistrate to make the findings that he did, including the inferences that he made, the law that he applied, and I do believe that the magistrate's finding was well supported by the facts as they apply to the law that's open in this case. So the motion is exactly that. All right.
I mean, he already made his mind up. He already made his mind up about that. Big shout out to cont'd for putting that together. Appreciate you. And make sure to subscribe. Make sure to give it a like and subscribe to cont'd, making things easier. Trial Channel being another one of those that do great work in the same regard. Yeah, you guys are amazing. Thanks for hanging out with me this afternoon. Thanks for hanging out with me on my YouTube presentation. You guys are absolutely fantastic. Make sure to hit the like for me, guys. Yeah, I know the audio really sucks. I got sick of that shit. Make sure to hit the like for me. It really, really helps me out. And make sure to subscribe. If you're not subscribed already, double check to make sure you're still subscribed. Hit the notification bell so you know that when I'm going live. And thank you guys also for all of the support. I'm really grateful to all of you for that. Let me double check here. I just want to make sure I didn't miss any okay. All right, guys. Thank you so much. Guys, all the support. You guys are absolutely amazing. I really appreciate you guys. I don't think I'll be going live again this evening. I might. Who knows? You know me. I always get a wild hair up my ass here and there. So we might. But if not, I will aim for doing a live stream sometime tomorrow. But I really appreciate you guys. Thanks for hanging out with me. It means a lot to me. I love you guys very much. Remember, it only takes a second to stay safe, and we will do this again very soon, my friends.
Watch out!
Today, being retarded means leading a full life. Retarded people go to work or school, just like their neighbors, and come back to a real home. A supervised home, right in the neighborhood, where they belong. Being retarded never stopped anyone from being a good neighbor.